to all summer.
Back to the future.
Yeah.
Because we can't get started trying to get ahead.
Something.
Because every
And
time.
I wanna see who drove, and I wanna see who drove their Maserati.
That railroad. I don't
Even a Model T probably wouldn't make it.
They got.
But just,
Oh, bad. I mean, they did.
so where should I find a
What's
seat?
what's the prognosis on the whistle stop?
Anywhere I want.
Maybe down there so you can see out.
So-
Interrupting people.
Remember FEMA
I'm already
yesterday,
interrupting Pete.
we're meeting with DES tomorrow.
He's sick, isn't that?
I told them, yes, all of them yesterday, I said, you realize I'm less than
Oh,
a
yeah.
year.
Come on.
No more extensions. So you better find somebody else who can know this project because it's not gonna get done. 'Cause right now, you haven't dealt with Joe, BGS.
Oh, yeah.
It might be easier on him. because then he-
BGS, it's just like everything's gotta go through
Well,
them.
I can go grab one.
So we literally, and we're having a meeting tomorrow, but if they stand with that, then we have to go out to bid to find an engineer. We have to contract with an engineer, and then
Okay, here.
we have to get all the details, and the engineer is gonna work with FEMA to get this all. Imagine how long this is gonna take.
Well, it's gonna be 3 years.
That's why I told him, I said, look, I'm out of here, I'm not gonna stick around. So I don't know, I'm hopeful that they will give us some kind of.
It's so bad now.
I don't know.
You carried that up.
Hey, buddy. Joe is like. he's
By
just-
the way, do you have anybody else who said they wanted to do?
I have,
Hey,
I have your
Madison
husband, I have,
Branch, I had a
Cardoza.
face to face with them,
I'm going by last
Private.
names and then,
nobody around, not in the
yeah,
building, and I
right.
said, you're either gonna get. this
Yeah, he
or
might.
done with this." And let me do it. I'm
So,
done. I'm
I don't know if
retired.
he
I'll
has been
tell all
on
of
yet.
the town managers and everybody
Uh,
that
Margaret Cardoza.
you
is very
wanted to do it
good.
your way, and
She's
so
here.
there'll be no trails.
So-
This will be forever.
I
You
think there
know,
was somebody else.
I'm the guy who knows that.
There was, yeah,
He-
she reached out
Because
just
he
like,
realized, he sent one of his
the other
guys
day.
out, they looked at what we were doing.
and then Neil, I don't know if she was 100% sure if he was gonna,
We don't want this politics.
because I was like, I think we're gonna have a session anyway for public hearing, so it may be better just to do it all.
So they stayed out of it completely. But we've got projects right now, that we got an engineer quote, and he turned it down because the engineer quote was too low. We were gonna do an engineer quote, he's turning that down.
On your phone, can you do a thing where up at the top, it gives you the choice to do more than one at a time?
That would be nice.
Like you hit, at least in mine, you hit edit, and then you can name the ones you wanna track.
And someone.
That might help a little.
So we have, one other person online who might want to give testimony.
Okay.
There was a third person who reached out, but he hasn't logged into Zoom
Yeah,
yet.
I should do it right. I should do it just once, but.
It's fine. Hey, Brian, and just say hi so I can see if we can hear you.
She said someone could come around the corner and get hurt if they really didn't stop to see that.
Can you hear me, Rebecca?
Yeah.
I understand.
I think she can.
Are you asking if I can hear you? Because I'm hearing like 4 people talk at once and I just heard my name.
Hear you guys, so thank you for doing.
Thank you.
Okay.
I wanted to make sure it wasn't on mute or the volume wasn't low, so, okay, thank
In
you.
the past, we have.
No, you're just being drowned out by everyone else's conversations.
Thank you.
Right. Shall we get underway? All right, call to order. We'll call this meeting of the Abandoned and Discontinued Roads Committee on October 19, 2023 to order. And we have a call of the roll, please.
Carla Black, she's out. Brian Bronson,
Here,
Peter Coughlin,
here.
Rebecca Graham,
Here.
Jim Katsiopoulos,
Here?
Chris McCabe,
Here.
Roberta Mantor, here, Vivian McHale, here, John Monk. I think he said he was gonna be out, we're gonna try. Catherine, I always see your name, last name on Nadeau. Nadeau,
So it's like NADO, NADO.
Nadeau, okay. Ryan Pelletier
Here.
and Steve Young. He's not here. Okay,
All right, let's start with the Is there a motion for adoption of the September 12th, 2023 meeting minutes?
So moved.
Second.
Okay, and those in favor? Okay, actually, let's do a roll call vote because we have a hybrid meeting.
Yeah, Carla Black is, Brian Bronson.
Here, I mean, in favor.
Peter Coughlin.
Yes, I do notice on page 3, there's a statue that should be statute.
Okay, I will fix that. Thank you.
At the bottom.
I like statute instead of statute. I don't
do it
know
all
why.
the time.
Rebecca Graham.
Heather, I second that and yes, approve.
Thank you. Jim,
Approved.
Chris,
Yeah, approved.
Roberta. Yes. Vivian,
Yes.
John is out. Catherine. Yes. Brian.
Yes.
Okay, it's Steve is not here. Okay.
All right, there's been a request to move public comment from the bottom of the agenda up to the next item. Is there a motion to do that?
Yeah.
Okay, is there a second, all right. Let's, all in favor. All right,
Rebecca raised her hand instead of Brian.
all right, it's just a procedural motion. I think we can do that, okay? Okay, so let's move the public comment up to now so that we can get folks back to what they need to do. Usually with our public comment, what we've been doing is 3 minutes, be concise, don't be repetitive, make your point, and we're glad to listen to you, respectfully listen to you. So with that ground rule, who wants to go first? Mr. Manager, you're right here. Let's hear it.
Basically, a lot of it could be a repeat. But there's something that has to be known right up front. In our US Constitution, we do have the Bill of Rights, but we also have a clear statement as to who can make law. Congress. In our state constitution, it's our legislature or the people on referendum. I question who else in the state can make a law? I.e., can the executive? Can agencies? Can the courts? No, they all have to follow and abide by the law, just like the claim I have. And I've been told by the state Supreme Court, the information was available, that I was supposed to know it all. Well, what I'm finding out is that in your own, let me get my glasses on, in your own, what you have to do, and Roberta said, I read through it, and she said, I need to come down here and mention it to you. That you have certain things that you're supposed to do, and I have some real questions about it. For example, you go down, this is on your duties. Commission shall consider the following: property owner liability, including personal injury, property damage, and environmental damage liability resulting from public use of an abandoned and discontinued road. Why don't you call it a public easement? Because that's what it ends up being. And that means it's a public road. Why are we expecting private people to be taking care of public roads? I can go down through this whole thing the same way. It's so, and the other word that is missing out of all of this, and I can repeat it, is closed. Because in my own case, the county commissioner said the road that I live on was closed to be retained as a private way. Well, honestly, if I looked at that and then reverse looked up what those terms meant, I wouldn't find out by statute that they meant what they were trying to say. So when you're getting into this, you really need to know that what was the badgering point with the legislator when we were back, state and local, was that they needed to know, and I'm going to use it, a method of something like minimum maintenance roads. New Hampshire's 1, 2, 3, 4, 5, 6 type of road, etc., so that municipalities would have an option. This is what we need to do, is to find out what kind of options we can set up for municipalities so they can legitimately be able to handle the roads. And you've got to remember, There are parts of the state that are totally swamped, part of it's rock, some of it's sandy. You've got to be able to make it so it's general enough so that each community can determine how to handle it. This business about all roads have to be safe and convenient to motor vehicles, or good luck, buddy, we're not, because I was promised an unfettered public right to use the road. And if you believe in the courts being able to make a law, somebody's responsible for making sure the road I live on is unfettered. And it wasn't me. I didn't ask for it. So the thing is that we've got to get away from this mentality of the all or nothing. And we've got to give municipalities different layers of roads that they can take care of, and probably consistent with the way they're being used, maybe weight limits to some extent, whatever. But having this and not regarding the fact roads like the town of Fayette said in their own town report, roads were legally closed. Here, I'm going to read this one to you because this is interesting. They quote down in the paragraph down below, this is a 1947 town report. We, the selectmen of Fayette Town, hereby petition your board, this is the county commissioners, to officially discontinue the following county roads situated in Fayette. What did that mean if I looked it up in the statutes? Not in the court records, in the statutes. It says, reason, they are no longer used and not kept open any part of the year. The town of Fayette desires to retain the right-of-way as it now exists on these roads. What does that mean? What did the county commissioners have authority to do? Now, if you back up on a private way, it had to be a person or persons who were being unreasonably refused and neglected before they could even get to the county commissioners to have it heard. This was the municipality itself. Were they being unreasonably refused and neglected? And what would a private way lead to? A singular property. And it would go over private land that's going to become public. But what they said in the paragraph before, the town of Fayette said, for years, Fayette has been legally liable for snow removal and road repairs on several roads that were grown up and no longer used. To correct this situation, we inspected each of these roads and petitioned the county commissioners to have such roads legally closed. I just read to you, town of Fayette, hereby petition your board to officially discontinue. What does that mean? All right. To have them legally closed. They held, the county commissioners held a hearing at the town hall August 21st, 1945, and as a result, officially closed the following county roads. But with the provision that the town of Fayette continues to hold the right of way, so that if in the years to come, these roads should be reopened, we will not have to purchase the right of way, trying to avoid just compensation, point blank. Proper signs have been posted on closed roads. Well, when I got there, there wasn't any, but there were ones on all the other roads that led into the north end of Young Road, plus a whole bunch of them around the rest of the town of the other 8 pieces, 7 pieces of road, all had dead end on them. Where I came in, there wasn't a sign at all. So it's just, what were they doing? What were they trying to do? Interesting note. You read what they told the townspeople in the town report. They never mentioned, the county commission said the roads, ought to be, the closing of the several paces of road be granted, to be retained as a private way, subject to gates and bars. Misrepresentation. And by the way, after this town meeting, February 1st of the following year, they sold my property that held on a tax lien to my predecessor, and they described the road as being discontinued. But yet, now it's open to the people to get to their camp. There's no other way to get to it. They called it a camp. It was a full-time residence of the person who lived there before. And I got news for it. People live in a lot worse than that, even today in this state. So, if municipalities want to play this game of permitting people to live in these places or selling them to whatever and legally hold on to the road, this is one thing. The municipality has to be responsible for taking care of the road for the intended purpose that they are permitting it to be used and or taxing it to be used. No ifs, ands, or buts. Because now you're taking my private property for a public purpose with no intention of compensating me. Plus, you're expecting me to fix your road at no expense to the municipality, et cetera, against my will. Try the 13th Amendment of the US Constitution. That's a violation right there. I may not be a slave technically because I wasn't kidnapped, but on the other hand, you can't make me work without pay against my will. That's why it's serious. We have to look at these things. We have to know what we're doing. We have to know those two other words. And we have to be able to explain to people why courts have been able to ignore the law to make decisions favorable to a majority of people in a town to force another person to lose their rights as prescribed by the Constitution of the United States. Sorry if I sound grumpy about it, but yeah, I've had my grump. Thank you very much.
Thank you, Mr. Manager.
Thank you for putting up with me.
Are there other members of the public who'd like to speak to the
Yes, I
commission this
have
afternoon?
Margaret Cardoza. Margaret, if you want to unmute yourself.
Good afternoon, Commissioner, committee members. I live in Portland. I have a seasonal camp in Windham, Maine. Recently the state local government passed LD 461, in which it goes into effect October 25th of this year, and has funded your commission to receive finances for compensation on the issue of terminology. Private way, private road, public easement, and public ways. And that you would be reporting to the state and local government any recommendations. I highly suggest that you offer the recommendation to advise the state and local government to remove the word private road from the title of Title 23, Section 3101 to 3106. There's a difference between a private road and a private way. Private way means that public easement is on a private road, thereby titled private way. Whereas a private road is exactly what it sounds like. It's private, and the owners could gate it off and stop the public from havoc on somebody's private land, which is their land, that road. The Judicial Committee had passed a law called Title 233121 to help make a separation between private road and private way, which is why I'm making this request for a recommendation to remove private road that state and local government had ended up putting into private way title. Now, let's hear those words that I've been saying. And how confusing can this get? A private way means public easement. But you hear the word private. So doesn't that sound like it's supposed to be private? This is where we're all getting confused. Then you have, a private road sounds very clear. It's private. But when you say private way, that's confusing. Is that private? No, it's not. It's a public easement. The word public sticks out for any normal human being that public means the public can use your land. I like what happened in my neighborhood. The town of Wyndham passed LD 1975 in the state and local government, where the Maine Municipal Association did not oppose this change, which I was very happy to hear the cooperation from the Maine Municipal Association to respect that Wyndham is providing winter maintenance on private ways. Now, private way meaning public easements. So the whole town and the neighborhoods, we all got together, and with the respect of private owners and the town, we have a mutual agreement. They'll help provide winter maintenance while we will make sure plows can actually get through. It's a wicked good deal. Now, on the other hand, we still have some other problems like ATVs or doing havoc on our roads. We have no police patrol services, so people can speed. And we've had a couple accidents, car crashes because of people speeding. And then there's the ticket. Where's the liability? Who do you blame? Well, that's the problem. Do you blame the owner? Do you blame the town? So there's some significant issues, and basically what's really challenging here, in agreement with what David's trying to say, what is the burden on private citizens, particularly what about that liability issue? I hope you would I sent a summary of what I said because I have a feeling I'm over my time. I lose track of time. But I hope, the challenges here is the language public. How confusing to any human being is the word public. And then the other issue is the word easement. When you have an easement, just like utilities and any other, there's some mutual responsibility. If a utility has, an example, water, they're going to rip through the road to repair it, but they're going to fix what they tore up on your asphalt and so on. So, I know the towns don't want to be burdened with too much expenses, but on the other hand, why is the town burdening private citizens as well? Very important questions, but I hope the terminology will eventually be clarified and something mutual and respectable could happen for all of us. Thank you for your time.
Thank you. Appreciate your input. Are there other persons with public comments for this afternoon?
I don't see anyone else online.
Okay. Well, thank you all. I guess that'll close the public comment section then. Updates and announcements. Heather, do we have anything?
I don't have any updates. The only thing that I wanted to bring up, I think, was when I was having the website to be able to give notification of our meetings, if I could take out the Zoom link, that way the commissioners, I can leave. The way I have it set up, because of the way IT has set it up, is that everyone has to be, they cannot messenger, like they can't, it goes out to the whole group chat rather than like individual. So it's just harder for them. They can't individually message each other. Do you know what I mean? Like on the chat or include it has to go through me in order for everybody to be able to see it. So I was wondering if they're testifying, they can reach out to me and we can send them the link for Zoom. Absolutely. Otherwise, I'd like to just put on our agenda just the YouTube link for the live so that they can see it or they can come in person. But I didn't know how the commission would feel about that. And I didn't know how the commissioners who are online felt about that. So I thought I'd just raise that.
Well, first of all, I think it's important under the Freedom of Access Act that we provide the link in our agenda so that folks can link on to that and that be available on our website. That's job one. As far as, we're worried about using chat function within.
As you know, like Portland and stuff, and even Hollowell, they've had some issues of
Right.
people joining within Zoom. We have not had that issue. I
Right.
think all of the people who participate are, but within the state, because we're a state entity and I have the state website, it limits the chat function. So I know a couple of times some of the commissioners were saying they can't.
Yeah, most of the time I'm
Right, so-
seeing that chat function being disabled for public
Yes.
meetings anyway.
Yes,
Because it's pretty hard to keep track of that and make record of it.
it is. So I felt like that was just something to raise.
Mhm.
I'm happy the way it is. Someone had mentioned it. I was like, I'm just gonna raise it.
Sure.
And then let you guys make the decision.
Okay,
Keep it the same. It's fine with me. I just had heard some people.
I would say keep it as is.
that's,
One other comment on the website.
Yeah.
I tried clicking on some of the links and the link to things like the meeting announcement and agenda works. But the one to, the DOT instructions for using the map viewer.
Oh, it works for me.
And
Okay.
there was another one, I think I can't remember now what it was. It was the very first one on the top right. I clicked on that. I think it was the record of what's already been done or something to that effect. Or the report that was handed in, that was it. The preliminary report to the legislature. I tried clicking on that and it wouldn't come up.
Because it was working for me. When we did it. So which one are you saying?
You just scroll down a little bit.
Yep.
Right there on the top under reports.
This one.
Yep. Yeah,
Okay.
that's what I got.
All right.
And I got the same thing on the DOT map here instructions.
That must have just changed
Oh, okay.
because it was working the week they put it in.
Okay, that looks like it's working.
Yeah.
I think what I clicked on was just above there where it had the underline. Yeah, see, that's the map here itself. It's the instructions.
Here.
Yeah,
this
right
one?
there.
It looks like it wants to download the instructions.
Okay, because what I got was the same message I got on the report, I think.
All right, let me reach out to Inform Me because there was the issue with the 132, it not letting me put it in and I got that changed, so. All right, so the instructions part, it looks like it's downloading into my computer, so that might be why. And then the other one was,
The report at the top,
all right,
2023 ADS, the
all
report.
right, I'll get that taken care too. I can actually probably fix that one myself. All right, okay, thanks for letting me know.
one major thing to think about under updates and announcements. Looking at LD 461 as adopted, we have a deadline coming up. And our report is due December 6th, 2023. That's pretty close.
I thought it was January.
I thought so
Seems like
too.
it keeps getting earlier.
Last year was January, I think.
No, last year.
I
was
thought it was,
February.
are you sure it's not January 5th this year? I thought it was.
Oh, it was January, okay, because I must, okay. I'm
I
looking
think
at the
January 5th, I
actual
think you
LD.
wanted it
Okay.
done by December 6th because we didn't want to go into the holidays with it.
Well, I think we need to submit it January 5th, so certainly that's a deadline.
Okay.
I have the proposed amendment to 461, and that's why. I'm starting to sweat. Okay, so if January 5th is deadline, then we need to adopt a report in December. So that's our deadline. Heather, we did a report earlier this year, and I think it's still available as a Word document, and it
Yes.
could be used as a template to update as
Yep.
far as, the cover and some of the basic stuff. And if you could please get started on that piece, that would be
Absolutely.
helpful for all of us.
Yep.
It would also mean less of a getting jammed in the holidays. So, all right, if we're going to do that, then what do we need to do? It seems like in November, we need to be making some decisions as to which amendments we're going to be proposing, what changes, what issues, what changes we're proposing to make and then starting to get the language together. Does that make sense? Starting to funnel down, we've got all these recommendations, all these thoughts from the two committees. The big picture is the legislature's told us to take a look at those words, those terms, and try to reduce the confusion. And that's private way, private road, and public easement. So I think that's really the first order of business, and we'll talk about that in the terms committee report. But I just want to keep it in mind. If we're submitting a report in January, we need to adopt it in December, and to adopt the report in final language in December. We need to, in November, make some hard decisions as to what it is we're going to propose and what that language should look like.
I have a thought on that. The report that's due in January, I believe, would be just on the LD 461. And then we're supposed to report annually on the commission as a whole. So would that be February again?
Oh, I would hope that one report would do both, but
I was just thinking maybe we could split it and have January to finish up doing the other piece of it.
It would be that hard to get the January because they worked so hard on it last year. So the template's already there. I have all the minutes typed up. A lot of it is just minutes, the budget. We haven't used any financing for budget except for my position. I don't think it's gonna be, if I start now, like Jim was saying, and I kind of already had started plugging away. And I wanted to show you too before you leave today, the index of testimony. You know, I'm trying to get ahead of stuff so it's there. So it might be easier just to submit one whole thing. Are you worried it's gonna get lost?
Well, I'm
In the
thinking we have
message.
so much to do. I just think that might give us a little bit of extra wiggle room. Much as I would love to have answers to the critical issues, you know, the sooner the better. But the definitions, I think you'll find if you go through what I've submitted, that I've revised it a couple of times, and I have another revision that I presented today, just 2 pages, right back to a page. So you may not have, I don't know if it's necessary to put in all of them and have people reading through things that are duplicated or that are now obsolete because it's a more updated version.
I think that's up to Jim and the commission, right, on what you're gonna include in the report for terminology and updating and recommendations.
yeah, the terminology piece is what the legislature threw at us. We also had our own thoughts as to what needed to be done, and we put those in our reports, and we've been looking at that under priorities. And I would just say as to priorities, what we can do, you know, to the extent we can get it ready, great. What we really have to do is deal with the terminology, because that's what the legislature put in front of us. So let's make that our priority, and if we can get other priorities that we've identified together in time, great. I don't know that we have the bandwidth to do 2 reports in early 2024.
What I'm thinking of is, as David was saying, and he didn't read through all of it, because I know he was trying to keep the time short, not succeeding. But where he read through the first charge that the commission was given before 461, it ends, you know, the problems for landowners and residents on abandoned and discontinued ways. And every one of those, I think there are 4 or 5 paragraphs right on the chart there, and they all say that's the issue: abandoned, discontinued roads and the problems they cause for the people that own land or live on them. So I don't want that to get pushed into the background because we've got this additional thing on top of it.
I hear what you're saying, Roberta, and I feel like once the state local government committee heard from us, they realized how massive the charge of the commission was in the enabling statute. So I think I have to agree with Jim that the focus of the report, and I think it should only be one report. I don't know what the committee would do with, right, exactly, one annual report should be the terminology, because that, I feel like they gave us our marching orders. It's not that those issues go away. I mean, this is a commission that is a standing commission. And then to the extent that we can identify priorities that we discussed in this report, I think that that's
Yeah.
maybe reasonable to put in, but I do think that we need to focus on the terminology.
Within the context of abandoned and discontinued roads, they'd like us to look at these 4 terms. And certainly there are a lot of landowner issues that arise because of confusion on these terms. And maybe we disagree as to the extent of confusion and how to fix it here. But it's our job to take a look at it anyway and make a report and propose legislation. The committee may report out legislation in response to the submission. So,
And being the first attempt at this first report with this deadline with specific directions on 4 terms, this is kind of a test for where we're gonna go and how they're gonna react and what success we're gonna have with the next report and the next report. So to me, we should concentrate on those 4 terms, see how it goes, which if it goes really well, then great, let's move on to the next high priority.
but this is a priority the legislature set for us.
Right, I was hoping maybe we could at least do a couple of the easy fixes, like on the small tweaks.
If we could agree on a couple of small tweaks at the same time, great.
Yeah,
And we can include them with the report, but we at least have to do this piece with 4 terms.
So question on that. The 4 terms. You know, we got private way, private road, public easement. But then last time Peter talked about town way, ways and public ways. Do those 3 all fit under the public way? Or what? Are they separate terms or?
They are separate terms. And I think in the end, we didn't have too much concern. Public way, we want to be a little more careful about.
yeah, there was a few places there that
Right.
seemed to be no-brainers that we should suggest, but yeah, I guess that raises the question, Brian, is the report calls out 4 specific terms, but what about the other ones that we all came up with,
Well, I know, that's the,
which are all connected?
I mean, we talked about street highways and
Yeah,
townways and are we? They all, like you say, they're all linked.
and it didn't say, yeah, it didn't say in here, those 4 terms relative to a section, it just said, review the use of the following terms in the MRSA's.
Right.
Right.
So that means 23, 29A,
All of them.
you guys,
Right, no, I don't disagree, but I mean, are we stuck on those 4 terms, or are we talking about highway and townway and? Or not?
Well, we have to address those 4 terms, and if we think there are issues with the others, then I think it's probably appropriate for us to talk about that.
right,
So, for example, Pete pointed out that there are 2 different definitions of public way. And actually more when you think about Department of Public Safety statutes,
Right,
DHS, Department of Corrections. And so do those need to be changed, or is the effect of those limited to those particular statutes so that we don't have to do anything different?
right, some are.
And that kind of keys into what I did on our last commission meeting, not the subcommittee, but the whole commission. I went back yesterday and watched a lot of the video. I didn't get through all of it, but I tried to pick out parts of it, but I seem to remember there were things that I wanted to look back at. And one of the comments was that the reason that private way is included in the definition, where it says private way means a private road, driveway, or public easement. The reason that those are all lumped in together is so that law enforcement can handle issues on any of those types of roads. So then I got looking at them and I realized that in the Title 23 MRS 1903, it says the definitions apply only to this chapter. And so I looked to see where in that chapter that term appears, and there's one statute.
Mhm.
So rather than having a definition for the whole chapter and having it only apply to one statute, why not just say in the statute what you want it to say? So I have an updated, proposal here, would be to repeal that definition. And then in the statute on approach signs, instead of saying any business or facility whose principal building or structure or point of interest, which is located on a private way, I said on a private road, driveway, or public easement is defined in section 3021, which is taken out of that definition. And then down at the end, again, where it says, signs to be located outside the public right of way limits within 300 feet of the junction of the public and private ways. Take out private ways and put in public way and the private road, driveway, or public easement. I think that would simplify that one, and it would get rid of that definition, so that somebody trying to find a definition of what is a private way isn't going to say, oh, look, a private way is a public easement. And, you know, or a private way is a private road, you know, which is it?
Right.
Then the definition in Title 29A, it says as used in this title. So it applies to the whole title, not to just one section. So again, I went through to see what there was in that title. And there are 4 places. First one is section 2053, right of way, private to public intersection. And it really sounds like it's talking about entering a public road from something that isn't a public road. And the question is, how do you define that something that isn't? So what I suggest here is, instead of calling it a private way, call it a private entry. And that says, for purposes of the subsection, private entry means any entry or road access onto a public way from anything other than a publicly maintained way. And the reason I chose that term was because that would include private roads, private driveways, and discontinued roads, which in many cases are public easements. So that covers that definition that was including the public easement. And so then it would say, for the purposes of the subsection, private entry means any entry or road access onto a public way from anything other than a publicly maintained way, including a private road, alley, driveway, or entrance, or a discontinued way, even if a public easement has been reserved. Which, the one thing that I changed a little bit from the definition in section 101 is it says, even if a public recreation easement has been reserved. And the only place that a public recreation easement is reserved is under abandonment, not discontinuance. And MMA has recommended that towns don't do that because they're constitutional questions. Then the next one, section 2063 has to do with bicycles, roller skis, toy vehicles, and scooters. And the very last sentence, it says this subsection may not be construed to limit the authority of the owner of a private way, and I said private road, or the owner of private property to restrict or allow the operation of electric bicycles on the owner's private road or private property. If it were a public easement, it would be the public to decide whether they're allowed or not the private individual, and the private individual would be the owner. Then section 2356, operation of a vehicle exceeding registered weight. Operation prohibited, a person commits a traffic infraction if that person operates or causes operation of a vehicle in excess of its registered weight on a public way. And then it says private ways exempted. This section does not apply to operating on private ways. Well, if a private way means a public easement, the statute applies to weight limits, but has an exception in subsection 6 for private ways. Since public easements are public, but are not maintained by the public should certainly have an interest in protecting such roads from abuse and damage. On privately owned roads, it should be up to the person who owns and maintains the road to allow or prohibit overweight loads. So the exception here should be for privately owned roads and not for public easements. So my suggestion on that one is private roads exempted. This section does not apply to operating on private roads. This subsection may not be construed to limit the authority of the owners of a private road or the owner of private property to restrict or allow overweight vehicles on the owner's private road or private property. And then the last one, I had trouble figuring out what it even meant. Pete says that it may apply when there's a construction zone and they have to build a road across the construction zone temporarily. So I didn't even attempt to do anything with that one.
I don't know, but in some of these instances, in my mind, I think the private way was meant to mean public easement. Nothing about this is going to be easy.
I'm perfectly willing to hear why you think that, and if you convince me, then yeah, we can put public easement back in there, but say it right in the statute rather than trying to make a definition that defines one term as applying to two different things.
Rebecca has her hand raised.
Rebecca,
Thanks, Jim. I would make a suggestion that we make no changes to Title 29 without consulting Lieutenant Bruce Scott from Maine State Police, as a lot of those definitions have been intentionally constructed to address enforcement issues on a mixture of property and avoid law enforcement needing to sort through ownership before.
I want
enforcement accidents.
I think there's a lot of it because of like motor vehicle stuff. Like, I mean, they're talking about like going on, like when you leave your property onto a public way, like, I mean, it's insurance, you have to have your motor vehicle registered and everything like that. So that's kind of where that stuff is coming into play, that like they look at that because like the person said before, who's responsible for the accident when this happens on a private way? So those laws are in place in 29A so that state police or any law enforcement can do the enforcement behind it. So I do think that would be something, a discussion for them, where they deal with that more than warden service does for sure.
I'm quite open to that. I would love it if somebody can show me where those definitions allow law enforcement aside from these statutes here. Because none of these, as far as I can see, have much to do with law enforcement. But you know, certainly if they need a definition that will allow them to do enforcement on both private roads and public easements, then we need to say so.
I think it's, I
I
mean,
don't see that anymore.
for example, I mean, we use like, if it's a private way, if it's a camp road or anything like that, if you live on the camp road, we get calls all the time, kids riding ATVs, oh, they're underage, they're not wearing a helmet. It's a private road. It's not our responsibility. We're not going down there. We're not doing enforcement. When the accident happens, we come down and cover it because it's a statistic. But the
Now,
reality is it's a private road.
now, if it's a public easement, do you enforce that?
I mean, I would say no, like.
Well,
it's-
that's what this
So-
definition is saying.
so
The
we're-
definition is if it's a public easement, you can.
The reason being is ATVs are allowed in a certain specific spot. It's either a designated ATV trail or you're the landowner. So if you're a landowner on that road, you're allowed to drive there. So you have a right to be there. So as Brian would say, like, it's a designated, ATVs are very simple. You either are allowed to be there, there's a green sign, or you have written permission to be there, or you own the land. That's where you're allowed to go. You're not allowed to go anywhere else. It's very simple.
Yeah, but that's fine. I have no problem with that. My problem is figuring out why we need a definition that only applies to these four statutes and doesn't seem to give you what you say you need. If there's a statute that gives you what you need, I'm all for it.
Well, I think that's what Rebecca was referring to, is state police may have a different opinion about with motor vehicle statute. Like with what they do for enforcement issues.
I would love to see that.
Absolutely. So here's the scenario. And this, you can actually, you Google this, Oxford Plains Speedway, private space, public parking lot, privately maintained, privately owned at any point in time, can close off access, has somebody who's operating OUI and creating a havoc around there. In order for law enforcement to charge for that, there is clearly an expectation that the public has been allowed to go there, has been allowed to operate there, but it isn't a public easement. It isn't an easement that has been given to the public. It is still owned by that entity. And at any point in time can flip ownership and not be a space in which someone is going to be operating OUI. Main Mall, same thing. That is privately owned property. There is by its current existence, a public expectation or an obvious public belief that there's an expectation that they can use that, but at any point in time that can change. Those operations and those particular incidents have been problematic from the law enforcement context previously, and therefore they had to go back and amend some of those statutes to make sure that you don't have to figure out, is this a public easement? Or is this just an implied public use by its construction and privately owned, and therefore you can drive OUI around the main mall? I think folks would not approve of that. So this has been constructed explicitly to try to deal with those and allow that enforcement operation on something that is clearly a space that is legitimately privately owned, maintained, plowed, everything else, but has a very clear public expectation of access and public expectation of adherence to operation law.
Yeah, but you're missing my point. My point is that I don't see that in any of these statutes. If there's a statute that says if it's a parking lot, if it's a place where the public is allowed on private property, then law enforcement has the ability to go in and enforce OUI laws. Show me a statute that says that, because I'm not seeing it here. I'm not seeing anything that gives law enforcement the right to do much of anything, except if somebody enters a public way from a private way without stopping for it. That's the only thing I see in here that might be a law enforcement issue, I think.
Every
But
single
if-
section of Title 29 is enforceable on the definitions of the roads that are at the front of that statute. So for the purposes of the statute, those definitions apply specifically to that statute. That covers all of it. It doesn't need to be in every single statute. It's implied because all of those definitions at the front of Title 29 address and allow the enforcement of all of the other provisions of Title 29 in those spaces.
Okay, I see what you're saying. Then
Yeah,
what we
it's the
need,
same-
what we need then is a definition that says that for purposes of this title, law enforcement has the right to enforce here. And not say that a private way means a private road or a public easement.
It says for the purposes of this statute, a private way. And then it lays it all out. And those are the things that you have pointed to before, saying if you took this definition and applied it in this other location, then that would be more beneficial for purposes of certain cases. But the reason that it is defined in there is specifically to allow the enforcement of those specific operational pieces. It's not to determine ownership. It's not to define ownership. It's to define powers of enforcement, which is a very different thing.
Then say so. We need a statute then that says that law enforcement has the power to enforce things in both of these different situations, not say these two situations are the same thing.
It says for the purposes of this statute under Title
Yes, but
20
it also
and make
says-
those definitions
But it also says a private way is. And
for the purposes of this statute. Essentially, it says what you're asking it to say. It's legalese. I get it. It's not clear, but that's the intent.
so that's like saying that for purposes of the statute, a horse means either a horse or a cow.
Correct.
Why not say veterinarians can treat horses and veterinarians can treat cows? Why say for purposes of this section on veterinarians, a horse is a cow?
Because for the purposes of enforcement, someone shouldn't need to worry and sort out ownership of what is clearly an operational matter. All of those have to do with motor vehicle operation. That entire section has nothing to do with defining ownership.
They won't have to if they can apply to either situation.
That is why that definition is very broad in Title 29. And doesn't point to others, because it doesn't want someone sitting on the side of the road saying, or side of a lane or a parking lot, gee, can I actually enforce this here? They shouldn't be sorted
But
down.
they won't have to if there's a definition that says that they can apply it to both. Why do they have to be lumped into one term when they're two different things?
This was intentionally constructed to apply to all of those situations.
So not that I know anything about the subject, in 29A 104, it said, except as otherwise provided, a person who violates a provision of this title, meaning 29A, commits a traffic infraction. So doesn't that mean that anything in 29A is a traffic infraction, regardless of how it's defined? Or am I way off?
I still think there should be a better way to define it, so that you're not saying that one term applies to two opposite things. If you want them to be able to enforce this entire title on either of those situations, then say so. And they won't have to figure out which one it is because both are covered.
Again, there are really important constructed court cases that have led to that definition change. So I would suggest that we make sure we actually consult with the folks that have to use it and make sure it's operational for them.
I agree with that.
So bottom line, Rebecca, is, as you said right at the beginning, let's check with the state police and see what they say.
Absolutely.
I'm all for it.
And just stepping back for a minute, where we have a situation where private way is now interpreted, 76 interpreted to mean to include public easements for purposes of Title 23. When you see the same term being used in 29A to include certain types of public easements where recreational easements have been reserved and private roads, you can see how that can cause some problems in interpretation. So I appreciate the issue. I think the idea of making sure the state police look at this is appropriate. I do like Roberta's suggestion with regard to Title 23. If there's a way to avoid using the term private way at all in Title 23, where it has a specific meaning already and could cause some problems, but let's avoid it. This might be a creative way to do it. So I would like to pursue that piece on Title 23, if that makes sense. Let's avoid within the same title having an issue on that term. And then defer on the state police to the other on Title 29A.
How do we get in touch with the state police to ask their opinion on that?
911? No, I think if the commission were to send a letter, and perhaps Heather, if we could put together a letter to say, here's the proposal that's been offered by one of our commissioners, and what do what's the state police's take on this if we were to make this sort of change? Recognizing there are members of the commission who might not favor this, but at least we want to take the temperature of the state police and find out before we do anything really rash or foolish or at odds with what the state would like to do. So, okay.
Margaret Cardoza wanted to say that there's no law enforcement on public easements. The police have made that clear.
Duly noted.
Can you repeat that? I didn't quite hear you.
Margaret, hold on, I'm gonna pull up the chat so I can hear it. She said there's no law enforcement on public easements. The police have made it clear who gets sued. Is it the town or the owner?
She may be right on motor vehicle law, but when you talk about recreational vehicles, that's not true. Because you can't, like I said, you can't ride wheelers in places that you're not allowed, and so we can go in and do enforcement on that. Snowmobiles, if it's a trespass issue, but motor vehicles may be a little different if it's public easement. So.
Well, if there's public easement, it's a road that the town has the right but not the obligation to maintain. And certainly if somebody does something to interfere with the ability to use that road, as some of us know, the town can step in and do something about it.
But they don't,
Well, they do sometimes.
rarely.
Well, when you dig a ditch across public easement, they will do something.
That's true.
Okay.
But if your use of the road digs a ditch straight down the road, they won't do anything.
That's called a wheel rut.
That's what I was just like, I've seen those before.
Yeah.
Down there.
That's right.
Oh, I have pictures I could show you.
I'm sure. So with that, then let's, shall we dive into the committee reports?
One other quick thing that I did, again, going through the video of the last meeting. I think it was John Monk who asked me, what proportion of the problem discontinued roads that I see are through roads or were through roads, and what proportion were dead ends. So I started going through the most recent ones that I have and just worked my way backwards. And the first 38 of them were all roads that had been through roads at one time. 3 of those, it was a little iffy. They were a double dotted line for a while, then they turned to a single dotted line, but they did connect to something on the other end. But the other 35 of them all had been through roads. And I found one that originally was a dead end. And then the next 2 that I found after that, which would have brought me to 40, were roads that had been through roads. Those are just going through the ones that I've had in the last year. I haven't gone to previous ones, but I think that's probably a pretty consistent trend.
Well, with that, let's get into the committee reports, because I think it's important to get working on particularly the terms, but then, also hear about the priorities too. On the terms, again, what the legislature wants us to look at a private way, private road, and public easement. He did help us though in terms of getting us started, because way, pretty common term. There is a definition for the term way in Title 29A Motor Vehicle Regulations. And it talks about meaning the entire width between boundary lines of a road, highway, parkway, street, or bridge used for vehicular traffic, whether public or private. So it's a pretty neutral term, and it seems to be one that doesn't cause much heartburn. It seems to be used consistently through the state laws. So we didn't find any issue with the use of that definition, that baseline definition, and our recommendation as a committee is to just leave that intact. Where we started diverging is maybe with public way. There's a definition again for road operation, for highway operation. A public way in Title 29A, that means a way owned and maintained by the state, a county, or a municipality over which the general public has a right to pass. When Pete was making his recommendation, because he'd done the research on this particular term, he suggested that we add to it that it would mean also any road capable of carrying motor vehicles, including but not limited to any state highway, municipal road, county road, unincorporated territory road, or other road dedicated to the public. That's a definition of public way that is within the billboard law chapter, the Main Highway Traveler Information Act. The purpose of that act is to make sure that drivers aren't distracted by billboards on the side of the road, and it's how Maine managed to get rid of billboards and to amortize them over a specific period of time. In the late 70s, Maine's legislature passed a law saying no more Joe Camel or whatever type of billboards on the side of the road. You see those in Massachusetts, you see them in New Hampshire, you don't see them in Maine. And it's because of this law. So the definition of public way there was meant to talk about your ability to view these billboards from a public way. So it's a slightly different definition, and it's focusing more on the fact that they're motor vehicles. There are drivers who could be distracted by these signs. At least that's my interpretation of it. Others may differ. I want to hear that. But for that reason, there's a different definition of public way for the billboard law. And I think it would be a mistake to graft that onto the public way definition for operation of motor vehicles on public ways. I think it's just better to leave that definition of public way alone. What do other folks think?
Well, if you're driving a motor vehicle on a public easement, chances are you're not going fast enough to go off the road while you read the billboard from beginning to end.
Well, folks might say that, and we should bring billboards back, but I don't think that's going to
But only
happen.
on public easements. Of course, I do remember one billboard on a New Hampshire road that was done out in fine script And we were driving back and forth past it, picking up hay from a hayfield with a small trailer, so we made multiple trips. And every time we came by, we tried to read another word or two until we finally got the whole thing.
So that could have been a distraction,
Yes, definitely.
maybe what Maine had in mind.
Mhm. And I still remember what it said. Said no investment increases faster in value than real estate. And it took us about 5 trips past it to read that.
We guess it was a realtor who put it up.
Probably.
Okay. So one of the things that Pete noted was that there are some specific definitions of public way. One with regard to roads and highways and lands maintained for the state government in the capital area. Department of Public Safety statutes, another for Department of Corrections areas and correctional facilities, and another for DHHS. What that means is in those particular titles, in Title 25 and Title 34A and Title 34B, the term public way is limited to just those roads of the state in those titles. And don't see any problem with that because they're confined just to those titles. It shouldn't cause too much overlap. They don't appear in Title 23. They don't appear in Title 29A. It shouldn't cause any confusion. They're limited in limited utility. Does that make sense? Okay, so do we want to just leave public way the way it is under Title 29A and not mess with that? Recognizing it's a different definition in the billboard law for purposes of the billboard law only, and in these other titles.
Yeah, I would agree, Jim. You know, the 29A thing, as you just said, billboard, the two definitions basically say the same thing. It just, the grammar is a little different, but they're both basically saying the same thing.
Maybe similar in import, a little different in their verbiage, but they are for their specific titles.
Right.
Or sections, so no harm in leaving them as is. That isn't the source of major confusion, it seems.
Right.
Well, that's one thing. So public easement. Put on your seatbelts. So it's a gravel road.
This isn't a 5-minute discussion like public way.
Oh. Public easement's an interesting term because it means so many different things or incorporates so many different ideas. I think that's the problem. Just going to the statutory definition, and there are two of them, or at least it gets referred to two different ways. The basic one is Title 23, 3021, so it's page 2 of the Terms Committee memo. Public easement means an easement held by a municipality for purposes of public access to land or water, not otherwise connected to a public way. It includes all rights enjoyed by the public with respect to private ways created by statute prior to July 29, 1976. Private ways created pursuant to former sections 3001 and 3004 prior to July 29, 1976 are public easements. So you have that whole definition. And then in the next section, the last paragraph talks about public easements laid out under the section are limited to rights of access by foot or motor vehicle as defined in Title 29A, which of course leaves out snowmobiles, ATVs, and electric wheelchairs. The type of public easement we're talking about in 3022 is where someone asks the town council, city council, or the town meeting to lay out a public easement to connect cultivated land through a public way. But those are what were formerly known as private ways way back under statute before July of 1976. So I guess the question I have, why is that there? And Roberta's answered with that there's a concern about the operation of particularly ATVs and snowmobiles on public easements. So that,
Mostly ATVs.
so it seems to me that if that's the question, if that's the issue, wouldn't it make sense to have just one definition of public easement? And then if there's a need to regulate the operation of ATVs on public easements, you could do that under the ATV statute.
Which I actually think we already do.
That's.
Well, you do anyway, but what,
But
but it,
ATVs didn't exist in 1976, so there had to be more to
Right.
this.
And that's where I'm, like, when I see that, I like, there's.
That was 1996, I'd buy in, but,
well, 3022 was actually amended with that last provision in 1995.
right,
So,
And I think they were there then.
then, yeah, no doubt.
So rather than say ATVs can't be used on just this particular type of public easement, which would lead everybody out there in the field be scratching his or her head saying, well, does it apply or not? Why not say if there's a concern, put it in the ATV statute and thou shalt not ride on a public easement. And it's whether the public easement was a leftover after discontinuance, whether the public easement was a leftover after statutory abandonment, whether it was a private way that became a public easement by operation of law, no matter what, if it's a public easement where the town has the right but not the obligation to maintain.
I guess the question for that is, and Brian probably answered, probably has the same question, but so does the town have a right to say that that's an ATV trail?
The public has a right of access over it.
But do they have right
So
access to ATVs?
So can they say, because you have to have permission to have an ATV on land of another without permission.
Mhm.
So the town can say that they can allow ATVs to go across that. Because no one can come across my property. There's not an ATV trail, but I can say, all right, Jim, you can come across.
Right.
You can ride an ATV out there. So does that, if the town has an easement, does the town have the right to say that that's an ATV trail?
That's the whole part of it.
That is the-
Yeah, we're in that in-between zone between a private road where you have to ask the landowner for permission and you have to get it. And a town way where you don't have the right to operate an ATV, except for maybe a limited period distance.
Access roads.
Right.
Right, well, access routes and or for the right of crossing.
That's what we run into.
1,500 feet.
Is the town has
Yeah.
has an easement, and they said that
Yeah.
ATV clubs, they can't go to Roberta and say, Roberta, will you allow me to ride across this, you own abutting property? So they go to the town and they ask the town, can we operate an ATV trail across this? The town says, yes, we have an easement, run it right through.
Well,
So if you say that you can't use it, then it forever closes it. Nobody can authorize
Right.
anybody to use it. That's the problem. There's gotta be a process, so it can be allowed if they choose to want to.
Right.
Or if you're in a butter and you have a right of way on it, for instance, because that's what happened last time, when they said. This doesn't apply to ATVs and snowmobiles, you can't use them if it's a public thing. Now, people who actually live there can't use them.
right,
Correct.
And I had put in some suggested wording on that where if the road is not being maintained by the public, then the landowners should have the right to decide yes or no on the ATVs. That means if the landowners are okay with an ATV trail, then the landowners could allow it. But the town shouldn't be coming in and saying, yes, this guy's maintaining the road, go use it for an ATV trail at his expense.
well, the problem too here is that the town can from year to year decide whether or not to maintain it. It
Exactly.
isn't an all or nothing deal. And so.
And the big dispute is actually ownership.
Rebecca, thank you. I was gonna call on you, so thank you.
I've had my hand up for a little bit. I think part of the problem is the way it's written in Title 12. Because it allows, first of all public ways are public easements. And it allows the governmental unit to declare those public ways for the use for that conveyance piece. And then as an access route, it's pretty prescribed, but that doesn't give a public process for that. It requires and it exclusively provides that it's the municipal officers as opposed to the legislative body. So if
But
there
we'll- Once the town opens their roads to ATV access, it's not a Title 12 issue. that falls, if they open public roads, they become motor vehicles and, the Maine Warden Service doesn't do enforcement of that. It's actually
29.
Yeah, the public access routes, that process doesn't apply to the discontinued road.
Right.
That's only to the roads that are maintained for public motor vehicle use.
It applies to any roads that were closed for winter maintenance, and the public way / public easement thing are the same thing in municipal law. So if it's a public way or a public easement, then that applies in that statute. There isn't anything notwithstanding public easement. And it conflates the two because of the public way. All public ways are public easements, but not all public easements are public ways.
I don't know that I agree with that, but.
If the definition of public way is a way for 29A is owned and maintained by a municipality.
Right.
A municipality owns a public easement, which is a right of the public to pass. It doesn't own the fee in it. Does that make any difference? And it doesn't necessarily get maintained by the municipality.
And that's where it always comes down to, because like if the town opens the roads, people start running the roads. But then we've had other situations where towns have a public easement on a right of way. And they say, well, we have an easement, we'll let the ATV trail go through there, because they're the ones that are making the decision to allow ATV access, because otherwise you can't ride there anyway.
Yeah, the problem is the way that is constructed is that there isn't a public process for that either. So even if the municipality wanted to have a public process in which it weighed and created some sort of maintenance obligations on that operation, there isn't a way for them to do that. They're not allowed to do that. It solely lies with the municipal officers.
I don't think that I don't like the way we're talking right here. I don't think a town is actually allowed on a public easement to say the ATVs can go across it. Right?
Well, that's the dispute, because, I mean, the law, Title 12 used to say that if it was discontinued, it was automatic, you could ride, you didn't even need the towns. But there are towns who say they have the authority and they've done it, and then there are other people that are disputing that. But because the problem that I've seen is who's actually the landowner. We need landowner permission. The town is saying we have a public right of way, so we're the landowner.
Right.
We have abutters who say, no, we're not. We have abutters who on the front end of the road say we're the landowner, and the people on the back end of the road are not. That's a big part of the confusion. But I agree with Rebecca. We've said for years that when they put this law in the books, we've got towns that just said, every road in town is open to ATVs. They didn't have public hearings, they didn't consider safety, they didn't do anything. They get really uptight with MDOT because they have a very animated process. And if we don't fall into that category, you don't get an access route, period. But that's a process that, probably should exist. But if we recommend that we overregulate towns' process, they'll probably throw us out of the.
Well, if the idea is that there's a trade-off, just one second, let me get this idea out there. Some kind of trade-off in order to allow there to be just one consistent definition of what a public easement is. And then if there are concerns about what's operating on a public easement, well, let's take care of that in the ATV statute or the snowmobile statute or the motor vehicle operation statutes. And
Yeah, I agree with that.
and that way it's easier for everybody, I would hope, down the line. Rebecca?
So the problem in the ATV statute is that it says it's a public way maintained or used for operation of a conventional motor vehicle, public easement, or on the sidewalks. So the problem is in that, in terms of the definition. So
That would include a public easement.
it would include a public easement, and that's the way municipalities interpret that, because it does state that in section 6.
Is that also though, so, because I didn't catch up, like public easement never caught up with the ATVs, because like it was a motor vehicle that they were allowing to go through a public easement. ATVs didn't exist when they first had it, so that didn't catch up with the times. As to, yeah, it's a traditional motor vehicle, like if a traditional motor vehicle can go through, an ATV should be able to too. It's just that they just didn't catch up with each other.
So you're saying public way and public easement in Title 12 are one and the same? Because they call it public way, but you're saying that is actually a public easement?
What we're saying is all public easements would wind up being public ways for purposes of Title 12 because
It allows a traditional.
it
motor
allows
vehicle.
access by motor vehicle. And it doesn't have, it's
Yeah.
maintained. Yeah,
It says publicly owned and maintained, or which a conventional vehicle is used, which would be a public easement.
But I guess like the thing that would fall back to, because it all goes back to ATV law and landowner permission, because ATVs are the only, like in trapping are the only two things that we have that are what we would refer to as reverse posting. So ATVs and trapping, you have to have written permission from the landowner in order to be there. Or it's a designated ATV trail from a club that's gone and talked to a landowner. So like,
Right.
you can't, so it kind of.
The problem though in this situation, because we're seeing it now, right now, in certain locations, even on Somerville. We can't agree who the landowner is under the road.
Right, right. And that's what I'm saying, like, it all falls back to who owns it. Cause you can't be there anyway.
well,
What's more important, who owns it or who maintains it?
who owns it?
Because it's the person who's maintaining
Ownership.
it. The person who's maintaining it is the one who suffers.
The person who owns it is the one paying taxes. That trumps person maintaining it.
Okay,
I
but
mean, if
it's
it doesn't, then the logger who trashes your road takes priority over you. And that's not what you want either.
wait a minute.
Because the logger is the one maintaining the road to get the wood out, but they didn't maintain it well enough. Their rights don't the landowner has got to have the ultimate right. If we lose that, we lose everything.
Okay, but you're saying then that the landowner is the person who owns the land under the right of way.
Right,
Not
which,
public.
and in some cases, the towns are insisting that's them. No, and it may or may not be them in these situations, I don't know. I mean, the town or the state is under our main roads, they're the ones maintaining them, we're not paying taxes on them, our survey lines end at whatever the broad width of the road is. In the case of these roads, the whole debate is there still a 3-rod or 5-rod or whatever road there? Or does both the butters own to the middle? And if both the butters happen to be the same person, then they say we own to the middle and they gate it, now you can't get to where you're going, we heard that last time,
Yeah.
right? So that's the whole crux of the problem is who really owns what there. And then when you get there, and I would agree with Chris that the whole intent, at least under Title 29, has been that ATVs, you need landowner permission. And if a club gets landowner permission and it's signed, great. If not, then I need to get it individually or I can't be there.
Okay, and when you think about a public easement is a road. Often it once was a town way, and there are people who have their buildings on them. It's been discontinued because it's no longer needed to be a town way anymore. People have moved out of those buildings, or maybe there were never any buildings there, just some walking camps or whatever. And so there are landowners. The landowners, in the case of the discontinuance, will then own to the center line, but a public easement is reserved by the municipality by operation of law to allow the public to have access. Why? Well, that means you don't have to pay much in the way of damages to the abutting property owners, right?
Yeah.
And the public can continue to have access there. So if you're going to operate an ATV there, who are you going to get permission from? The municipality may, but doesn't have to, maintain the actual public access, but the municipality allows public access. The public is allowed to keep going out there, and you have private landowners. It seems to me that access trumps ownership in that instance, and you probably want to go check with the municipality as to whether ATVs should be allowed to operate on it.
Well, and that's the reason why the last round of amendments said ATVs are not allowed on them, but from that date forward, because they didn't want to go back and undo this previously, and that's been the discussion point. There are some who said, no, they should just not be allowed there at all unless they have permission. And then there's others that have lived through the whole mess and said, yeah, but you can't get permission because Roberta could potentially not even be able to use it on the road that she's on because the guy up front says you can't be here.
Right.
And that's the both sides of this. And that's why they did what they did last time, because it does change things.
Rebecca, Brian, any particular thoughts on that?
I think that when we talk about public easement, we need to keep public in mind and remember that it is the public that owns that easement and the town is the one that's been in charge of that. So it's not necessarily just the town's on it. That the town is maintaining it and has to go through those transparent processes to allow the public the opportunity to extinguish them. I guess that would be my statement. So with regard to the way that the ATV statute is there, the clear issue that we want to avoid is cutting off access to publicly owned resources and publicly necessary access issues. And with regard to the ATV trails, if the issue is about maintenance, then I think we can be tweaking Title 12 to make it clear that there has to be some sort of obligation for maintenance if it is going to be on that, either by the folks that want to access it or not. But I think that that's kind of where it is rather than focusing on the definition piece, because I think that the way that Title 12 has written it out has actually conflated it, because it doesn't actually even talk about public easements specifically. It just talks about conventional motor vehicles. And these are places in which conventional motor vehicles go. So I think that
So let me ask you this.
that are disconnected from the definition of public easement piece.
Does the town, I mean, are you saying that we should put in here that the town would have to provide maintenance, or that there would just be some kind of maintenance agreement? Because I've consistently said that in these scenarios, we can fund maintenance through the program. We can't fund maintenance on DOT's public roads because it's a public road. And
That falls onto municipalities if it's a
by the town or county or whatever as for a public road, then we can actually provide funding to help towards the maintenance. And we've done that. And I've said right along that, you know, if clubs or towns or whoever we're working with have rather than just drive their will against somebody who lives on these roads, let's sit down and say, look, this is what we'd like to do. We'll help, with grading, with ditching, with calcium, whatever, to do the maintenance, because generally speaking, that can provide a better outcome, and people are more inclined to say, all right, as long as it's being maintained, we're all right with it. But the big debate has been, I've had town selectmen say, no, we can't do maintenance and we can't let you fund the maintenance. Because that, I don't know, the whole liability, I guess, like a person can't plow or a town can plow, but once they've said they're not going to do it, they wouldn't even allow us to funnel grant money through the town to help the club maintain the road. That's what happened up there recently. Remember that whole?
You're talking about discontinued roads?
Mhm. So I'm with you, Rebecca. I think if we could tweak Title 12 to make it clear that there should be maintenance and that we can do the maintenance and that doesn't conflict with something else, I think that's a good outcome. It's just that what I'm consistently hearing inconsistent results on that. Depending on which town you deal with, you get very different pushback as to how they interpret this to work. That's been our.
So one of the bigger problems is that it's constructed in a way that copes with roads that is not constructed in any other way. So municipalities, and I know that this has happened in some municipalities, who recognize that they have designated an ATV, they get someone that comes in, a club that comes in and wants to do an ATV trail. Sure, sounds great. They do that and realize that there is a public easement that is being used, and those folks are really upset about that. they can't hold a town meeting to do that because the statute explicitly says it is only the officers that have that and not the legislative body. So I think one of the problems would be that there is a public process that was dropped into designating an ATV trail that included public hearings and included affected parties to have an opportunity to weigh in. I think that's probably step one of
The
that.
law says, as directed by the appropriate governmental unit. So why does that, how does that exclude a municipality from having a public meeting?
The way that it is constructed, it says municipal officers, municipal, where is it?
This is in Title 12, Rebecca?
Yeah.
But it doesn't say that it gives them the authority to make the decision, but I know of several towns where they put it on a warrant, had a town vote before they authorized it or didn't. So.
I know
You
that,
know-
I know that it's been looked into the past and that was the outcome, that they actually couldn't do that because it solely lies with the municipal officers.
Yeah, well, backing up a little bit, but I'm still kind of wondering if it's a public easement, is a town allowed to say that an ATV can go across it?
They
Because
can
it talks about
if it was
motor
just,
vehicle.
right now, they can if it was established before a certain date, and they can't if it was established after a certain date.
Yeah.
That's current status.
Right, and it's unlikely that a police officer or a deputy sheriff or a warden is going to be able to make that determination out in the field.
Oh, they definitely are.
You know, I mean, it's foolish.
Yeah, it's not possible.
And so the question is, why do we do that?
Right.
And if the concern is ATVs generally, then make it a general concern and deal with it in Title 12. Instead of having two different types of public easement, which just doesn't make a whole lot of sense.
So it's in section H, actually. It says that appropriate governmental unit means DOT, county commissioners, or municipal officers within their respective jurisdiction.
Why
Right,
is
no, I agree with that, but your interpretation of that means that they can't have a public meeting?
Yes, it means effectively that the decision solely lies with the municipal officers.
It does, but they
That's
can
not a
still.
legislative body decision. Legislative body decision is town meeting.
Okay, but why is that a problem? Because there's a whole group of things under Title 38, Section 3008 that are specifically for municipal ordinances to be adopted by the municipal officers. Why can't this be one of those things?
Right.
You could say after
Because
notice.
it doesn't have a public process and it doesn't allow for the obligation, in order to obligate funds that has to be passed to the legislative body. So.
All right.
And it also has to have, and if you're gonna be looking at the maintenance of those roads, then it should be the legislative body that is weighing in because they can't appropriate without that. And
Well,
that's,
the problem that I have with what you're saying is that you're saying that the town should have a right to vote whether or not to allow ATVs on the road that I'm maintaining. And,
if
you know,
the town,
be able to outvote me.
it's a public easement. So if the town is gonna appropriate money to provide for that maintenance, all appropriations of funds for that provision, as you know, because you've petitioned for that maintenance, have to go before the legislative body.
Roberta's point is, what happens, correct me if I'm wrong, if the town decides not to fund that public easement and Roberta's out there fixing that public easement on her own dime, is it a municipal decision then still as to whether ATVs can go on that road? Or is that something that the ATV owners can petition the landowners for?
Under current law, that's the way that is written. So
Is that,
they can operate because you can put a
Motor
car
vehicle
down
on?
that road. There's an expectation that there's a car that can drive down that road.
you haven't seen some of these roads, Rebecca.
No.
I-
Roberta, I live on one. I live on one. I have
Well-
seen those roads. I do know these roads.
About the law,
Does
Roberta.
yours have 2 foot deep channel down the middle of the road where it's washed out because the
It has a
ATV?
Pit that has been dug below the water table. How's that?
Sorry, say that again?
There's a pit that's been dug below the water table. I am not, I'm not talking about the maintenance fees. I'm talking about the way that the law is written. So the legislative body has to vote to appropriate funds, period. If there's a process in which you would like that to happen under Title 12, it isn't constructed in a way that allows that to happen currently.
Can we,
That's
to move past,
impossible.
if to move past this, can we delegate to the members here who are most interested, delegate the task of preparing an amendment to Title 12 that would make this work?
You know what that would be?
Well, the problem, I'm still stuck on this a little bit because like you still have to have permission to go across. So if the town decided that, like Roberta said, that they didn't want to put the money into it, then there's not a trail there. You can't ride a wheeler there. It's not a trail. You can't ride there. You can drive a truck over it, but you can't ride an ATV there because it doesn't meet a 29A definition of a motor vehicle is different than an ATV that we were just discussing.
Right.
So you can still, if the town decides they don't want to have an ATV trail there, it's not an ATV trail. If someone's riding an ATV there, they're illegally operating an ATV, whether you live there or whether you're Joe Blow citizen down the road.
Well, but that's the crux of the problem, right? Because how do we fix that and allow a
Right.
butter to
I know.
legally be there?
It's a blanket. It's not a,
And that's,
not
I'm not sure how you
fully-
get there.
I don't know.
So Margaret.
Well, you could
Carter's-
remove used for operation of conventional motor vehicles from Title 12.
So
Okay.
what would that prevent guys with pickups to go down the road hunting?
Potentially. Those are the things that we have to unpick. That's
That's what I'm thinking of, like,
That's what I think the pushback was before.
Margaret Cardoza had written, and she said the Fish and Game Department oversees the ATVs regulated by the game wardens. The issue is that Fish and Game have informed landowners they can travel on public easements. ATV owners, they can travel on public easements.
Well, that was in the law originally.
Yeah.
I think we amended that and took it out when we put mandatory landowner permission in place back in 2004 or whatever it was, but prior to that, it said you could.
What if the law were to say, and just throwing it out there, that in the instance of public easements that are maintained by the municipality, the legislative body may grant permission for ATV operation on the public easement?
I think that sounds pretty good.
And we're putting that in Title 12?
Yeah.
I can live with that.
Rebecca?
I was just trying to paste the section,
Sure.
but it's too long. It said I have to send shorter messages.
Yeah. So basically what you're saying, if I understand this right, is if the town wants to authorize it as an ATV trail, they would have to be providing maintenance.
Yes.
And if they're refusing to provide a maintenance, then they do not have the authority to authorize it as an ATV trail. In that case, the club would have to be working with every abutting landowner along the way.
Well, the town would still have authority over the use of the public easement. You know, it'd still be, you know what I mean?
They can still drive trucks through.
So,
Yeah, it's still-
so I'm thinking about how to fund that. Like how would you fund that?
So I mean,
Easiest way to fund that.
we could provide, like I can provide grants to the club or the town and however they want to funnel it. To do maintenance on these roads, and we do it. And in several towns, and that's part of the trail system, and that, these sections of roads are part of it as well. But then there are other towns who say they can't do that. And that's the big discrepancy out there that seems to be unclear.
And the reason they can't do that is because they don't have it in their budget and they have.
No, it's pass through money. It's not, it's actually, I mean, they vote to do it, but it's state
have to
funds.
vote.
They don't actually use their own funds. We just pass them through. But they do have to vote, but what some towns have said is we don't have the right to vote to do that, and other towns regularly do it. And that's where I've always been a little confused.
Why do they say you can't?
Yeah.
I don't know, they just flat out say that the impression I get is that they are setting a precedent by maintaining a road that they've agreed they won't maintain.
Say that again.
They don't want, they've made a decision that they have a public easement, but they're not maintaining the road. And agreeing to maintain the road on my dime still is them maintaining the road, which changes what they've previously said they would do.
Yeah, because this would have to be an instance where the town meeting would have to agree it's responsible for maintenance.
But I
Right,
think, and you can make an argument, yeah, you could very easily make an argument if you're maintaining it for ATV, does that mean you now need to maintain it for winter passage? When like roads closed for winter passage, you can automatically operate those vehicles on, there is that permission that's given.
Right, yeah.
But they might require maintenance during, summer maintenance. So does that preempt? There are solid arguments for that maintenance piece that I can feasibly understand.
I have a question. On a public easement, back to November 17, 2022, which is the definition. A public easement is an easement held by the municipality for purposes of public access. Yeah, we have that. And it includes what formerly were known as private ways. So this is two of our definitions that are now put into public easement. Is it still that way? That some of the public easements were also known as private ways?
yes.
Yes.
Private ways go back to colonial times almost, where back when we were part of Massachusetts. And it was the idea that I have a farm and I want to connect to the nearest public way and I will give you the land,
Right.
call it that. And it becomes a private way. Over time, the public started getting rights in those. And the legislature in 1976 said, yeah, those are all now public easements. That the public has a right to pass over and the town has the right, but not the obligation to maintain.
So that means the definition of a private way has changed.
Yes. They changed the name of it and changed what it was at the same time, and now they say it's the same thing that it was before, which it isn't.
And yet we still have private way definitions elsewhere.
Yeah,
I know. That's the whole crux of this mess.
so would cleaning up Title 12 clean up some of these definitions? Because these definitions are, as far as I can see, as far as I've been downloading here, they're all over the place.
Yeah, but
I mean-
Title 12 is only referring to them as public ways.
Yeah,
But we're not, we
It
don't,
doesn't refer to public easement at all.
but
But
What
it
is the-
refers to the vehicle, which is the ability for a vehicle to pass
Right.
or vehicle operate. So that ends up sweeping them in.
so that's a problem. So what,
Problem is with that is some ATV trails are like dirt roads where there's more vehicles can drive. And then you would have to prohibit all motor vehicles from ATV trails or vice versa if you don't want vehicles.
Well, no, because the majority, so there's public ways out there that are gravel. And they're maintained by the town.
Mhm.
And they may allow use on them under an access route or whatever. Those aren't the dispute. The dispute is where that ends, the road continues and the town says, you can go, but we're not doing any maintenance. That's the road in question that becomes dispute. And if off of the public way, you have a private road, or I have a private road, a warehouser or whoever, and they authorize use. They can do that. That's an ATV trail. We can help maintain it, whatever. There's no issue there. The issue becomes this section of you know, Old County Road, Old Town Road, whatever you want to call them, they refer to them as a million different things out there. And what's the status of that road? And who has authority to say we can use it, and what limitations are there on being able to do maintenance? Because we've got towns that are saying you can do it and you can maintain it. We've got towns saying you can do it, but you can't maintain it. We got towns saying you can't use it. And in some cases, you can't use it even if the abutting landowner says you can use it. That's the reality of what's going on out there, and it's all due to confusion. How do we fix the confusion is the $1 million question here. I mean, we may be able to tweak Title 12 to help, but I don't think it does anything to the underlying public easement definitions out there.
Well, we've been talking about this for over half an hour. I was hoping that that we'd be able to come up with some kind of easy solution as to how to fix this one glitch with public easement, because it does
I
have.
like the verbiage that you.
I think what you said under Title 12, I don't know that it'll get through the legislature,
Well, I
but I think
understand.
it makes sense to try to say that if they're going to, if a town or the appropriate governmental unit, whoever, is going to
Maintain.
allow ATV use, they can only do it if they're maintaining.
Yeah. Is that something that Chris, Brian, and Rebecca can maybe swap some language? I don't want to invite an online meeting.
Another subcommittee?
Yeah, really.
No,
we don't need that.
No, but maybe, you know, can we see if there's some suggestions that might make sense that the three of you could work out and let me know what you're thinking of. And then we can bring them back for the commission to look at for the next meeting.
I had some language that I'd proposed someplace, and I can't find it right now, but there was something that I had proposed about, I'm trying to think now how it was worded. Something to the effect that, with landowner permission, I think it was on private roads. I said, ATVs are not allowed on private roads except with landowner.
but see, that's already law. We're not gonna pass that again, because it's in there. Private roads, you have to have landowner permission. Private land, you have to have landowner permission.
But I think this.
Public roads maintained for motor vehicle traffic, you have to have the appropriate governmental unit's permission.
And who is the
The
appropriate?
public, well, it's
government
either
unit on public
MDOT or county or town, depends on who maintains
And
that
for the
road.
town, it would
funds
be,
the
what
road.
we're saying is it's the town's legislative body, and the idea is to address the issue of you maintaining a road for ATV use, which doesn't seem fair. If the municipality is maintaining the public easement, then the ATV could, with the
So
municipality's
they
approval.
could allow it. The
Right.
question then becomes, so if they're not maintaining it,
So
and then they're not gonna allow, you know, so they don't have the authority to allow it. Is there still a process in place so it could be designated? Because you don't want to eliminate that, because you have existing situations out there where, I mean, my take as program manager has been consistently to tell clubs, don't try to drive your wishes down anybody's throat. Go to them and say, we'll help. We want to use it. Town says we can, but we understand your scenario. How can we work together to help with grading or ditching or whatever? And we just spent, I won't say where, because it'll probably be recorded, but about 15 grand on one of these roads this summer. Just to try to balance this debate between the towns and the club and the landowners. And I said, look, guys, let's just do this. I'll fund it. And when we did, all the problem went away.
You're saying if a road is maintained, it can't be an ATV trail. How about if it's maintained by the landowner and it's?
Well, that's my point. I think if it's maintained, it can be used as an ATV, and if it's maintained by the landowner and the landowner allows it, it should also be able to be.
Well,
I think
that
that
last part, though, is a little bit of a problem. I think Rebecca would jump in on that because the town still has there's still a public right of access. It's just the town isn't maintaining the way. Does that
But does
concern?
somebody maintaining it for ATVs, does that interfere with a public the town's public right of access? I mean, if we don't restrict it, if all we're doing is adding gravel and grading, how is that?
Are people using it for additional motor vehicles?
Go ahead, Rebecca.
How are they gonna?
Because a municipality must maintain, if they're going to maintain a roadway, it must be maintained at a certain standard. And they can appropriate funds, but only with the will of the legislative body. So they can do it to a standard to make it possible. But if there's going to be any sort of, on these, they don't have the obligation, on those particular roads, they don't have the obligation. And the way that it's written doesn't allow them to ask for that.
That's where we've been talking about minimum maintenance roads. There should be something that allows them to maintain roads to a lesser
That's
standard
what I agree with
than you're saying that, forces the town to spend money they haven't got.
I know, what's the?
Right, but you're not gonna put that in Title 12, that doesn't help.
No, that would have to be with regard to public easements.
That's why I think there should be a lesser standard that way, because then Brian could come in with his crew and do maintenance. And it's not up to the standards of the town makes, but you can still drive through with ATVs and trucks, but it doesn't have to be the.
I mean, I think you
standards.
could very easily add that maintenance for this purpose doesn't change the fact that a town has discontinued or change the status of a road.
Right,
It would require another vote of the legislative body. I think you could put that caveat in the Title 12 statutes.
Do you wanna take a stab at adding or whatever on paragraph H is what we're talking about, right?
my only thing about that, Rebecca, is like I know, where it goes, I don't really care if it goes in Title 12, but it sounds like really the hindrance is that towns have to maintain these roads to a certain standard, which that's not in Title 12.
Right, agreed.
If it's a town way, it has to be maintained safe and convenient for passage by motor vehicle.
That's
That's the
a-
standard.
That's
That's the standard for town way.
That's it.
That's for the town way. And then there's private road where the town has no right
There
to
you go.
be.
Simple.
Yeah, and in between is the public easement. There's no standard for that. And a town doesn't have to maintain.
And they're not gonna want, the towns are gonna line up against us if we try to put a standard in there, because that's gonna cost them money.
Right. Right.
I think that if we can avoid doing a standard, that's a far better option, saying that, that if you maintain or designate an ATV trail with the will of your legislative body, then your discontinuance of those easements, if you're going to let them go or whatever, doesn't change. Like that status doesn't change. It still requires another process to actually accept that road. I think that's a little bit different. I think there's just needs to be clarity in that statute, but that's very different than saying you need to maintain it to a passable standard for a motor vehicle, which is both in the statute as saying allows you to designate if a motor vehicle can pass, it allows a designation or allows the town to designate, which would be a public easement on a discontinued road.
Paragraph H, when it was drafted, because I was there, had nothing whatsoever, no intent anyway, to do with discontinued roads. It was allowing access routes on public roads that are maintained for public use. That's how it got done. So
So that's why you have towns saying they can't do it. Probably because that's what the intent was, but the language, the legal effect of the language is something different.
right, I think the discontinued town road really doesn't fit under paragraph H. in
Well,
Title 12.
if there's a public easement reserved, yes.
But it doesn't say anything about public easements, and it wasn't talking about discontinued roads at all. It was about opening public roads that are maintained for ATV use. Same
So-
thing they did with Somerville.
So it's a public right of way that's maintained by the town meeting.
It's a public road that's regularly maintained, yeah.
Well,
That was the,
Section D is the one that says public way or one that's used for the operation of a conventional motor vehicle.
right, and that potentially, we should just eliminate paragraph D. Because
The problem is you're gonna lose a lot of the current ones and passageways, the access ways.
Well, right, but is it, if we eliminate paragraph D, or maybe we add in something about you can use it if you have landowner permission? I mean, because what we were trying to get at was when landowners should have the right to say yes or no. So maybe we leave H alone and we tweak D or eliminate D or rewrite D, because D is really the one that's applicable in my mind. H isn't. I mean, I hear what you're
In
saying.
terms of administering or appropriating funds and providing permission.
Yeah, and I mean, that makes some sense. That makes sense to me, even as an access route, because frankly, we got towns out there with access routes in places they shouldn't be. They don't invite me to their town meetings anymore because I tell them just the way it is and they don't want to hear that, but the discontinued road part, I think, is fallen under more under paragraph D.
Yeah, one thing I agree with you on, Rebecca.
Whoa, don't have that much.
I forget whether it was you or Brian that said something about setting a precedent. Towns don't want to allow maintenance of one of these roads because it sets a precedent. And this is an argument that we've heard over and over again is if a town agrees to take back one discontinued road and resume maintenance, that they'll have to do it for every road in town. And that's kind of a false argument because usually not every discontinued road in town has anybody who cares or who lives on it. Lots of times it's just one road with several people living on it, and it could be a good public interest to take over the public maintenance of that road for fire and police protection or whatever. But the other 21 public easements in town, nobody's asking anybody to maintain them. And other people will say, oh, it's a precedent. If you take over maintaining that road, I want my private road maintained. Well, no, private road isn't the same thing as a public easement. A private road, you can keep the public off of it. A public easement, you can't. So when it comes to precedent, there should be some way to say that doing one road doesn't set a precedent for all the other roads in town. It's just for that one road.
Yeah, I agree. They have permission right now to appropriate funds for that purpose. They do that on a regular basis. They do maintain roads that they don't have to because there's a public easement on it. But again, it's the legislative body that has to appropriate those funds for that purpose. It's not the municipal officials. So I think that there's some concern because there's a difference between residential and ATV trails. There's a difference between the expectation and the public expectation, who uses them and who needs access. And I think that that's conflated enough in Title 12 that it deserves probably some consideration and makes it kind of tricky.
You keep saying that there are towns that do maintain roads that they don't have to maintain. You keep asking me for examples where they don't, and you haven't given me any examples where they do. Would it be possible for you to give me some examples where towns have done that?
Yeah, actually, you're the one that provided that example for the legislature. And then also, I think you said last time that the town of Fayette appropriated money to help maintain your road, but did it when you guys weren't at town meeting or something? You made some sort of statement that they had appropriated funds, you had petitioned for that, and they had appropriated funds.
The year you weren't there, somebody else made the petition and they passed it.
Well, yeah, what they did was they passed the permission for towns to use the public funds on private roads or on public easements rather. And then when anybody actually asked them for the funding, they said, no, they weren't going to do that. They would only do that. They would only use the town equipment on the road when there actually was an emergency. So in other words, if our house is on fire, then they will plow the road so they can get to it. And by the time they get there, they might as well bring marshmallows. Or if I have another stroke, they will then plow the road so the ambulance can get there. And by the time they get there, I will be brain dead.
Well, there are a number of examples that you also provided during the legislature. So I know that you're aware that they do maintain them and that they have the opportunity to maintain them. My road is one of them that they do. They are not obligated to maintain, and they do.
If you can remind me what those examples were, because I can't think of any where a town has, well, it's with the exception of the town of Wyndham, where they're doing it on private roads.
Nope, that is a special law. That is a special law that they are doing, and they needed to receive the easement for that purpose because they can't use that. You pointed to a certain town official that said, this is an obligation that we should be doing, and then they appropriated money for it. Do you remember that example that you provided?
Yeah, that's the only example I can think of, and that was not even a public easement.
No, it has to be a public easement or they can't. And it's the same with my road. My road is a public easement. It's not a public road. It is maintained. Or
Okay,
passed.
we're trying to deal with public easements and getting a single definition and saying that they're all the same. They're in a special class where ATVs can or can't go. I think we've come up with an idea, a construct we can work with to run down. Are there other issues with regard to public easement, that term, and how it's used in state law?
Did you, did Heather send you the process on analyzing an easement?
Yeah.
If you don't have it, I can share it on the screen. Let me know.
That might be helpful.
Let me pull it up.
Just so and everything.
I don't think I.
Like 5 or 6 attachments, that was the one.
Okay. We look for it.
If I write a TV,
When I printed that process off, Rebecca, I don't know who this was from, who wrote it.
Not unless it was a discontinued town, not a private. See, the reality is I get it's confusing because of private ways, but it's not a private way that you build on your own or warehouser does. It's not the same definition.
Do you want to cross? Yeah.
Okay, so who put together this process to analyze an easement status checklist?
We all need that.
Okay,
Who put it together?
So these are what folks need to, like, this is what towns need to understand and go through as they're going through that status. So I think that there are some hinging points in there that we should be cognizant of, because I think there are some public easements in general that we should be thinking about.
okay.
Is there anything in the public easement language that differentiates if there's a public land on the road?
Good question.
You could establish a public easement in order to get to a public
Right,
resource.
but is there anything that prevents you from discontinuing maintenance or whatever if there is a public resource? Because I know, I mean, for instance, and I don't think it's official that it's public, that's the issue, but I know there are a bunch of these old cemeteries out on these roads that people struggle to get to in case, because of nobody's maintained road anymore.
That's a whole other
I know.
source of headache.
But it's on these same, because we've seen those roads gated off, people can't get to the cemetery. And,
True dead end.
and it becomes a very interesting scenario. Kingsbury's got a bunch of that going, and they ended up opening all those gates.
Mhm. I don't think we're gonna,
No, I know. And again, I'll admit, I thought I understood this just gets more confusing every time we get into it.
well, our job is to try to help clarify it.
I know, but I don't even know where to, I don't know how we start.
The other thing that ties into that, Brian, is that lots of times I've heard Rebecca say that these public easements were kept so that there would be access to public land or water. And that's not necessarily true, because under section 3026, a public easement was automatically retained anytime a road was discontinued. Same thing with 3028.
Right.
There was an automatic public easement. whether or not there's any public land or water. And in many of these cases.
Absolutely. And that was specifically to avoid landlocking because they had landlocked a bunch of parcels.
Right. And there are people out there landlocked right now.
And the reason to avoid landlocking is so the town won't have to compensate them for the loss of access.
And for the reason
Comes
for,
down to
yeah,
money.
and with regard to the statutory abandonment provision, with regard to the retention of an easement for public recreation. That's there because of the lobbyist from Maine Audubon, as I understand, who happened to be Angus King at that time. And we're still not quite sure, and I'll have to ask him someday what he was intending.
That gets interesting, because if you read the legislative discussion when the bill was passed, there was a whole long discussion about whether or not to keep a public recreational easement. And they went back and forth on it. There were some people who said that they thought it was going to be a problem because these roads are going to get torn up by public use with no public maintenance. And there were other people who said, well, but on the other hand, if these roads are suddenly closed off and people walked and hiked on them and snowmobiled on them for years, and all of a sudden somebody puts up a gate and they can't get there. Well, if they had realized that by saying that it takes a road that has been abandoned under this section takes on the same status as it would have had after a discontinuance under section 3026. And they had just changed 3026 at the same time to say that it keeps the public easement. Before 1976, back in 1965, they had said that it keeps a private way.
Right.
And I think a lot of the legislators didn't realize that by tying 3028 to 3026, they were saying these are automatically going to be public easements. If they had realized that, there wouldn't have been any need to keep a recreational easement because you can get there anyway and nobody can gate it because it's a public easement.
Right. What can I say? So are we okay with public easement, and we have some duties delegated for homework for 2 people, and I'll try crafting that piece.
Yeah, yes.
Well,
We're gonna try, but I don't.
that's okay. Trying is a big help right there.
And if you're going to say that ATVs are excluded from 3021 and 3022, I'm okay with that.
Right. That's the trade-off.
Okay, doing it the other way around, I would not be in favor.
Understood. Okay, that gets us through public way and public easement, 2 of 4 terms. Woo!
We've got almost an hour to go.
We're cooking. Yeah. We started at 1:30. I don't know what time folks want to stop at with your schedules. We could probably be here till 8 o'clock if we wanted to deal with the private way and private road, but I hope not. Which should we maybe pick 4:30 as an end time?
Sure.
Do we need a 5-minute break now before, or we just power through? Power through? What a tough crew we have here. Okay. All right. I could try to speak for Roberta, but I don't think that's a good idea. I think it'd be better to hear from Roberta directly with regard to private way and private roads, seeing as how you put together those summaries and see where that takes us in the discussion. Roberta?
Well, I haven't changed a whole lot from what I presented the last time. There were a few small tweaks in it, and there was that paper that I kind of went over already with the suggestion addendum. That had mostly to do with the definitions. But what I'd done before was I went through and picked out the ones that I thought were easy fixes. And there are a lot of them. There are some where I think it's pretty clear that what they meant by private way was public easement. And there are some where I think it was pretty clear that what they meant by private way was private road. And if we just fix those, that's a big start on things. Then there were some that were more difficult, and I went into suggestions for those. I'm not sure if I have in front of me what I had presented. I think I've got the stuff I had for the other committee.
I did put together the memos that you had assembled for each of the terms, private ways and private roads, and put those together with our memo to the entire commission. So maybe that would be a place to look.
Here we go. I got notes on Westlaw Church, a private road, started by sequence and urgency.
You did one for private ways, maybe we start with that one first. Westlaw Private Ways Revision Suggestions. Which is the most up-to-date one you've given me. That's what I sent out with the materials for today, or had been sent out, I should say.
Yep.
I don't know if I have that for you or not.
I sent out a memo to the commission from the terms committee. It's dated October 14. And with that, I included Roberta's private ways, the most recent private ways and private roads memos.
I mean, it's the term, it's probably in with the terms memo, it's like a little memo. And then behind the and then within that little zipper file, there was Roberta's 2 attachments. I'm gonna share my screen with that, if that makes it easier for
Yeah.
everyone.
that would make it
Let's
easier.
just do that.
Okay.
I mean, I didn't try to rewrite it. I just keep it out. It's so good. I agree.
Okay, so we're gonna start with private way or private road?
Private ways.
Okay.
Ah,
Give me a second.
It's okay. I think the first change Roberta
The
has,
same problem.
Are you?
Yeah, they were zipped and instead the file was too long. I had to rename or something. I couldn't open them up.
hmm.
Yeah, well, so much for trying to compress stuff to make it easier to send stuff. There we go.
all right.
Ah, good.
The first one was 1903, and you addressed it in the summary today, I think, by a creative way of just taking out the term private way from that section. That's the
I'm gonna
billboard.
share my screen so those who are online. can
I
see.
think that's okay, and we can move on from there.
Okay, good. We've got one.
Got one.
Okay.
So then when you look at 3021 and 3022, if we're,
Yeah, that was, you already attacked 3021, 3022.
yes, I think we're okay with that piece.
Yeah,
I mean, it uses private way because it's an old term, and so it just,
yeah, there's some other things that I'd like to do with that. I think we've got to start on it just by saying that neither one allows ATVs. But the other piece that really is a problem with that is that it takes all these old private ways, which were never expected to be what they are today, and says that they're now public easements. And it seems like we almost need two different definitions, one for what are now public easements and one for what they were intended to be in the first place. And as I was saying earlier, that very few of the ones that are problems are dead ends. Almost all the problem ones are ones that are through roads, and the original term private way was invariably a dead end. And here we've said, well, all these through roads are now the same thing as these roads that were supposed to be dead ends. And that's where a lot of the problems come in.
okay, but a lot of those roads, the through ones, are because they're old county roads leading from town to town
Mhm.
that were discontinued, leaving a private way subject to gates and bars, is what you find in most of those old deeds in the 1900s.
Mhm.
And those, as I read it, those became public easements, and I think you disagree.
Yeah, private ways originally were only supposed to be laid out to a property, which would mean it would have to be a dead
I
end.
understand that was the
Where
traditional
we
way.
got into problems with it was where towns and counties both realized that sometimes when they discontinued a road, it left people landlocked. Because the road went back to private property to the center line, and it would become a little patchwork of all little pieces of private land to the center line. So the first two people on the road might be able to get there, but anybody behind them would be
Would
landlocked.
be at the mercy of the two front landowners.
So
Right.
what a lot of towns and counties did was they said, well, let's keep a private way. And I think what they meant by that was to do kind of the same thing that they've done on these dead ends, to say that this is access primarily for those landowners. But the problem is that because it was a through road, there were people that continued and still continue to this day to try to use them as through roads. And they don't have any particular interest in the properties. They don't have any ownership of the road. They don't have any stake in maintenance of the road. That's where the abuse comes in.
Well, or potentially, but even with those dead end roads, over time, the public had rights to use those dead end
Right.
roads, private ways that were from the farmer to the town. Eventually, the public was using those, and by the 1940s, before the term public easement ever arose, you were seeing a private way subject to gates and bars being referred to in state law court decisions,
Mhm.
referring to these through roads and the shorter roads. So I view them as being the same at this point. The public easement sweeps in all the old private ways, however they were created, whether they were leftovers from discontinuance by county or municipalities, or created as one-way routes to try to get from agricultural areas to town.
But should they be the same?
Well, I think they are the same.
I think, one of the smartest things I've seen, and I didn't run across this until I had the same idea independently, town of Newburgh. In early 1976, just before the county roads all became county ways became townways. There were some landowners who petitioned the county to discontinue the spur of road to the town line, because people were coming in from the other town and going in and out and chewing up the road. And the last 4 owners in the town of Newburgh wanted to stop the through traffic. And they petitioned the county to discontinue the road. And the county said, if we discontinue the road, it's going to leave people landlocked. We will not do that. But
But the town was willing to.
no,
No, okay.
no. The county was smarter than that. The county said, but if the landowners will agree to get together and grant each other private easements, then we will discontinue the road to the town line. And the landowners got together, they granted each other private easements, and the county discontinued the road.
Not doing that nowadays.
Well, that's sort of what wound up in the discontinuance law,
Exactly.
right?
And
In
like I
in
said-
2018. Right,
Yeah, in section 3026A.
right.
And that was my suggestion that, this is a solution to it, is make them into private easements and then allow them to be gated or at least posted as being private. And, the landowners won't have to deal with everybody and his brother coming through and using it any time of the year, any time of day or night. We'll have some control over it.
But that goes to the process of how you create a public easement, not the definition of one.
But the two are tied together, because how you create it ends up affecting how it gets used. In other words, if you create it by laying out the road at the request of the private landowner who's going to benefit from having a road to his place, and knowing that, well, yeah, the public has a right to use it, but how many members of the public are going to use it to get to my mill who aren't interested in coming to my mill? There's no other reason for coming in the road. But then you have public easements that are laid out simply to avoid the necessity for compensating people for loss of access. And it's a through road, which results in loss of access because the public uses it and doesn't maintain it, and that destroys the road.
So do you want to have 2 different types of public easements?
I want to have 2 different terms.
Okay,
For public easement? That's a bad idea.
No,
That
not,
just makes the problem worse.
not 2 different terms for public easements, but 2 different terms. One saying a public easement is an easement for use by the public. And another one saying that this dead end road or whatever was laid out for the purpose of access to these properties.
so that a private way that was laid out to connect agricultural land or went to a public way isn't a public easement, it is something else, or
Yeah, and that's where
Is
it
that-
gets sticky,
is
is how
that-
you define it, because the public does have a right to use it, but probably only in a limited fashion. It's not a wide open, everybody can use it whenever, for, for whatever purpose.
See, I don't think that distinction exists now, and that would be a new distinction that would cause confusion.
It's already
No.
confused. We definitely don't need more confusion. But see, this is my problem, is that they've taken something that was intended to be one thing, and to avoid confusion, they've lumped it in with something else, which makes it confusing.
Yeah.
I understand the
I
argument.
totally agree with you on
Yeah.
that. This is, I mean, how a private way can be a public easement is,
Why would they include that in with a private way? That changes the whole definition of a private way if you include a public easement in it. So just saying,
Well, it goes the other way. Private ways are considered public easements. I understand.
but they're also considered a private road or a driveway.
well, yeah, but that's a separate thing. They're not really. If
Well,
Weyerhaeuser
I'm
builds a
looking at the
private road,
definition up there,
that's
but
not a private
I'm looking
way.
at the definition up there.
But that's one definition for the state highway sign law.
It means a
Yeah,
private road,
that's-
driveway, or public easement as defined in section 3021.
Yeah, that's where I had a new suggestion on that, just
Right.
get rid of that definition and just say in the billboard law that this applies either to private ways or, to private roads or driveways or to public easements.
That doesn't
And
apply
not say that
generally.
there's one term that applies to both of them.
That's a special
Just get rid of
definition of
that.
private way for just that one section, and we can get rid of it, and then there isn't any confusion caused there. Otherwise,
Take a public easement out of it?
Just take out that whole definition there. That,
the private way definition,
take out that definition.
The private road, driveway, or public easement?
Yeah.
Take, and put in what?
Then you take that terminology, a private road driveway, a private road or driveway, or a public easement, and put that into,
the section of the state
Section-
highway sign law that we need to
yeah,
limit.
yeah, so that the highway sign law says that it applies to, private driveways or to public easements. And it doesn't say that they're the same thing, it says it can apply to these two different things.
That way we won't have private way meaning two different things in the same title. I think that's an elegant solution, and Roberta, thank you. But I,
Here's the- it's on this one page, printed front and back.
It says private way revision suggestion.
That got some today.
Yeah,
Yeah,
Yeah.
again,
halfway down the
Came out
front page there, says approach signs, see where that is, in section 1914.
yeah,
So instead of saying, located on a private way and defining a private way as being two different things, say, which is located on a private road, driveway, or public easement. As defined in section 3021.
see, I don't like the public easement being in there with private way.
Well, at least
At
it's
all.
saying, at least it's saying they're two different things now. Before it was saying that they're the same thing. It was saying that, a private way means either of those things. And down here, it's not, it's saying a private way is a private way, but, a private road is one thing, a driveway is another thing, a public easement is another thing, and this applies to all of them.
this works.
You see that, Kev? So that the original definition in their private way just said it's private or public easement. It's both. But what she's suggesting is that if you just eliminate that and take those words and stick it down in the approach sign section, you're saying specifically a private road, a driveway, or a public easement.
To go back
So
to
you're
the,
defining, separating both and not calling it public and private at the same time.
to go back to the analogy I used earlier, suppose you had a law that said, definitions, horse means a horse or a cow. And then you have another statute that says a veterinarian may treat a horse. meaning that he can treat a horse or a cow. Just take out the definition and say a veterinarian may treat a horse or a cow. So that's basically what this is doing. It's saying that, this is for signs that are approaching a business that's not right on a public road. And it says that, if the business is located on a private road, or if the business is located on a driveway, or if the business is located on a public easement, you can have a sign out on the public road.
You're more than 1,000 feet away from the nearest public way. Yep.
So another little minor point there, when it says private road, comma, driveway, or public easement, am I implying that driveway is also included as private? You kind of saying private road, private driveway?
Yeah, that makes clear. You could put that in there.
I don't think you'll find a definition of driveway.
Yeah, that's what, so I'm gonna argue what's the definition of a driveway, is it public or private? So just say public, private road or driveway. Or
We're just continuing the same, whatever defect there may be now, we're pulling it out and continuing it. If driveway is whatever it is, I think alley is used in another statute that Roberta pointed out.
Yeah.
Right, it's on the next page. And it doesn't have a definition in here. Public, private, I don't know.
Well, so is there such a thing as a driveway that's not private?
Yeah, I was gonna say,
In other words,
it's a
public
public
driveway.
driveway.
I can't think of one.
I mean, what is a driveway in and out of, say, a bank?
private.
Belongs to the bank. So, yeah, we could say private road, private driveway, or public easement.
And there's really no such thing as a public driveway, because otherwise it would be a public road.
It'd be a public
way.
Right.
What about like a municipal driveway, or like I'm here at the courthouse, what is that driveway considered?
Public.
What's that?
So it's probably a public driveway.
Public easement.
Well, it's definitely public,
It is.
right? Because the other definition that was worked was specific to capital security, all of that language around state office buildings.
Right.
It's public way for those purposes.
But in that case, you wouldn't have a private business that needs an approach sign.
Where that's down below though.
Yeah, that's the context of what this is used for.
So just leave it as driveway, then it can be both.
Let's, whatever,
That'll come up in another session down the road.
I'm sure.
Down the road or down the driveway?
Down the private road.
Down the easement.
Okay, are we going on to private road now?
We're getting closer.
Okay, what's the next thing on here?
All right, so hold on, let me get rid of,
This, we've got through town ways and public easements. I think we've generally got,
okay.
we generally had a direction, but I think there's a concern that Roberta's raised that the way that you get a public easement may direct you to have a different treatment or a different standard or for them. I respectfully disagree, but I understand the reason for the difference, your distinction between the two. You get public easements because they're leftovers from discontinuance or abandonment of a through road. You can get public easements because of the old private ways that were to take cultivated land and get a route to town. There are also public easements that arise because you have a recreational easement to get to the beach for a lake or to a river or something. I don't know that those are all different. I treat them all the same, but you would consider them different. How do other members of the commission feel?
Well-
I absolutely hate having a public easement in a private way. I understand, but I can tell you that this is gonna be a sticking point for when it goes in front of state and local. Is that public easement part of a private way? It's gotta be, it's the verbiage. I don't like. And
They're the
you
ones
can
that put it in
understand
the
it.
law.
You can understand it. But I'm just gonna tell you when they look at these definitions and they look at that.
That's why I'm saying get rid of that definition, because it's the definition that confuses it.
But you have it in here, private road, got rid of the private driveway, it's now a driveway or public easement under private way. You still have that,
But it's not under private way.
but it's not under private way.
No.
What is under private way?
There is a
It's
definition.
gone.
It's gone.
That's.
Private way is gone.
The definition of private way is gone in that chapter.
Perfect. Okay, then that won't be a stickler.
Good.
Thank you.
Yeah,
There
okay.
is a definition under Title 29 of operation of motor vehicles. Yeah,
And that one only applies to 4 statutes. So again, it might be possible to just get rid of the definition and just have each statute say what it means.
That's the one where you need Lieutenant Scott to weigh in.
Great.
I just want to comment that, I live on a public easement that was created by action of the municipal legislative body accepting the road as a public easement, not by discontinuing a former public road. It was a
Brian,
private.
does that allow access to some public recreational type facility like a lake or a river or any? It's just, okay. It can be done for that purpose too. It doesn't have to be, but okay.
What would be the reason that they would have done that? Just a-
Because we were 50 or 60 landowners living on this private road, and we just, politically got the municipality to agree that some level of maintenance would have been fair, and they didn't want to accept it as a town road. But we went with the public easement because then that gives them the control of how much money they're going to raise and appropriate to put towards our road on an annual basis.
But it takes everybody to come together for that.
Yeah, they don't plow our road. We hire a private contractor to plow it, but they allocate so much money a year to our road association to help with that cost. The only way they could legally raise money to provide to the association was if the town accepted it as a public easement.
Sure. And that happens. That's not totally unusual, but,
I'd say it's unusual, but it does happen.
well, the road association piece is a little funky, but, but that's interesting. It can be done. It also shows that road associations, there's a road association statute. We're gonna get there. It's a little down the road, but we'll get there. And it's not just for private road owners to get together. It's also for people on public easements to form associations and maintain roads that way. So when it says private ways, private roads, and
I'm not gonna get into
yeah,
that. Okay, can we scroll down? We'll skip 2021 and 2022 for now.
It's up to
I would do that. Okay, yeah, here's the 29A.
right.
And this was the one where we said we had to get in touch with law enforcement.
No,
what they're
no
saying.
private way.
Okay, so let's skip down to that. Skip all of
Is it
29.
private?
I think that's about the end of it. Okay, other statutes.
They people that live on. Right with you. Conservation and child.
Okay.
I have a private driveway. I can't do it.
Yeah, these were ones where I thought that in many cases, what they meant by a private way was a privately owned road. And maybe for homework, we could have people go down through these and see if they disagree that these. If they
Where are
think
we?
it's something
I don't have
else. Title 12, conservation.
So that was in the packet with the memo and the 2 things attached. And we're on private ways.
That you emailed, right?
Yes,
No, I guess I don't have it.
I have it up on the screen. If
Yeah.
anyone-
That's great, because it's in here somewhere.
I'm sorry, there was a lot of documentation that went up for this last. Section, and I tried to organize it the best I could, but
Yeah, I tried to print it all, and I may have left it on the printer, it may run out of paper.
That's probably why I didn't have it with me either.
if I had more time, I could print them all. If it makes it easier for those who are coming, I can have everything printed out when you guys come, you just hand you the packets.
Oh, that would be,
Those who are in person.
what kind
No.
of coffee you like? How do you want it? Yeah, that would be awesome.
I'll do that for the next meeting then.
Donuts, you want donuts? I'll bring them.
Got enough donuts to your meeting.
You did, that's true.
I'll have them all printed out next time and then I'll just put packets like I did for Roberta's and a few other things. So I'll just make sure those are there.
So the premises definition there, it's got to have something to do with law enforcement.
That's what I was just, I go, that is search warrant written all over it.
That's the only reason why that's there, and it probably can't be changed because of that.
But do they really mean private ways? Do they mean public easements or do they mean privately owned roads?
It's
They mean all of the
all
above.
Encompassing everything and
They do not want to vary to find out whether they just stepped on a private road or a private way, or they're still in a public road or whatever. They just want to know they're good to go.
So then it shouldn't say private ways, it should say
Private road.
private roads or public easements.
Well, if you eliminate, that only works if you actually eliminate private ways, like you're suggesting to eliminate. They haven't done it yet. Keep that in mind. I mean, we can't
But what
fix
do-
it here
but what
if
do they
they
mean?
don't fix it there.
But what do they mean by a private way?
driveway, like private
Private
road,
road, driveway,
camp
or
road.
public easement.
name it,
Just say way.
I'm hearing private,
Mm.
everything you say there,
camp road.
private.
Yeah, but that's why they're saying
Hold on a
private
minute.
way,
All the
So
above.
privately owned road.
but it's not
But it's not,
necessarily.
it hasn't
Could be a
changed.
privately owned ATV trail.
Okay,
Yeah.
how about privately owned way?
Ugh. Private road, private way, privately owned way.
I know.
The rest of the story, I guess for Mike, this has nothing to do with the real issue because this is strictly about them getting the search warrant. So do we even need to mess with it? Cause it's not controlling use of your road in any way. It's just allowing law enforcement to go where they need to do a search warrant. So why do we need to mess with it?
So technically, if we did away with private way, then there's a problem with that definition where it says private way.
That definition of private way pertained only to just about 10 statutes in Title 23 only. So we're not worried about it here in Title 12.
Okay,
So,
that was gonna be you can't have a warrant because
yeah,
No.
I'm on a private road, not a private way.
Yeah, 'cause Kathy, in Title 23, as Jim just said, it says definitions apply only in this chapter, Title 23.
Okay, perfect.
That's the
So-
same with Title 29 and Title 12.
yeah, I mean, right here in Title 12, the section that Roberta has, these definitions apply only to Title 12, Part 13, subsection 14. So I
So
think
we
could
really
probably
shouldn't
leave
be
this
touching
alone.
this at all
That
then.
one stays the same.
Yeah.
I don't think you messed with that one.
Mhm.
2304. The idea here is not that we're going to make the definition of private way consistent through all 38 titles of main law.
Right.
The idea is to try to reduce the confusion. And the confusion usually arises because you have Title 23 talking about roads and highways and Title 29A talking about operation on roads and highways. And then Title 12 with snowmobiles and ATVs on those roads. Those are the ones that are really going to give us the most, but here in Title 12, it is specifically talking about a definition for that for that title only.
And that should be in the report, Jim, what you just said. That, yes, our task in the thing was to report by January on those 4 definitions, but we're only looking at the ones that you just said, because the other ones are very narrowly defined, so we're not touching them.
At this point, we're not making any recommendation for those
Yeah,
others.
that's a good way to put it at this point, because, you know, maybe when we've done step 1, maybe we can go on to.
Well, I mean, but that's my fear is we try to all encompass this and then
No,
they don't buy it all. And then we've created a whole nother set of problems because they changed one place which didn't work because they didn't change the other. I think as hard as it is to accept, you have to take this step by step.
And I agree that these have not been causing a whole lot of problems, so.
Even the problem, like what we passed last time, and we thought was perfect, right? And now people who live on the road can't use their ATV on the road, you know, so we try to do too much at once.
Mhm.
It's funny because the next one down, I was just looking in the new Title 12 and it says the executive order effective April 21st, 2020 related to COVID-19 state of emergency modifying and suspending laws enforced by the Department of Animal Fisheries and Wildlife because it's about registration of an animal. So we suspended registering animals at the game stations at the time. So it's gone back. We're now registering them again, but
But it's fundraising.
it's.
Revenue.
Okay, well, what about the operation of snowmobile? Do we want to rehash that, or we've already hashed that one enough?
Thirteen 106A. Where are you getting private?
So it's controlled access highway.
Would that be a public way or a public easement maintained for travel?
So
Yeah.
this section is very similar to the ATV section, and section G under snowmobile is the same as section H under ATV.
Yes.
Mhm.
And it's all the same scenario, which was the intent was strictly snowmobiling on a road that is maintained for regular vehicle traffic, over and above the normal 1,500 feet.
Mhm.
They can make them snowmobile access routes. There's less snowmobile access routes for sure than there are ATV, because any of you in snowmobile know trying to drive down a plowed road with a snowmobile is not a lot of fun.
Yeah, especially
But
when
there
you
are
get the
places
snowplow
where it
coming out of the
happens
way.
to get businesses, gas stations, restaurants, whatever, in towns like, you know, Millinock, Jackson, and other places, they drive right down the street. So this is the same, at least intent wise, it was all the same.
So why isn't the answer the same?
I think it might be. But again, it may not even need to be a mess with in this case.
Well, I guess the thing is, do we want to use this term private way in this statute with regard to snowmobiles? Is it meant to be a private road, or is it meant to be a public easement that the town has voted to maintain? As with ATVs.
Could be a public easement
Yeah.
on a discontinued road.
Or do we take out the private way and just say road maintained for travel?
I don't like that.
It's kind of weak.
Isn't that the point of it, is that you don't want a snowmobile operating on a road that's maintained for vehicular travel?
Do or you don't?
Yeah, yes and no. I mean, the reality is, like Brian said, some places, when you're trying to get into town, that's the only way that you can get there.
Mhm.
Like we deal with it when trails get shut down and we get permission to run up roads. It's not as far, certainly, but
Well, and in downtown areas,
Well, I think
even
Ryan
in
was saying
places
that-
like Chapman, you know, they run the streets, so you're not running through everybody's backyard.
yeah, I think Ryan was saying that there's a big one up his way that they use.
Danforth, there's one right on the main highway. Snowmobile access route, you know, where it crosses Baskehagen and the railroad tracks and all of that, they run right down the whole length of the road there.
Oh,
But
and
that's
up here in Oxbow Plantation, it's like 5 or 6 miles. They use the road.
Well, I don't know, I mean. Is it, I mean, up to this point. Is snowmobile the issue? I mean, ATV has been
Yeah,
in
that's
many
no bill,
cases,
don't really
but,
hurt the roads much.
so. If it ain't broke, don't fix it.
The one issue I do see is, where we have people complaining that there's a discontinued road within 20 feet of their house. And the snow bill law says that there's not supposed to be a trail within, or that ATV or the.
Well, both say that, but if you're on a public. I don't know how they, if you're on a public road or whatever, that doesn't apply. So you can't have a trail with that close to your house without your permission.
Right.
But if that operation is happening on the road. Probably public way, public, who knows, but I think it says public way, then it can be closer to your house than that, just because the road's there. So yeah, in that scenario, the old discontinued town road is closer to your house than 200 feet or whatever the.
Okay, let's move on to Title 14. Limited liability for.
I don't. Well, the current new public easements established after 2022 or 21 or whatever it was. Snowmobiles can't go, right? Unless they're
85, yeah.
well, actually, it says ATVs and snowmobiles can't go, period. It doesn't even allow a process for them to be allowed, which is another whole problem, but.
There's a lot of snowmobile trails use the old discontinued roads.
They've just eliminated any process to be able to get them authorized. And to allow the butters to use. That's what's got now. Nobody's enforcing that.
And
But
we don't
that-
mind the snowmobile trail going pretty close to our house because it makes a good place to walk the dog in the winter. It's a nice 2.5 mile loop. And it comes down Young Road, then it goes across private property, then it goes down Surrey Road.
Let's move along on limited liability. That's Title 14, and that's. I don't know that we.
So the question there was the landowner liability law says that a landowner is not liable if they basically let us recreate, right? And what we discussed 2 or 3 meetings ago, it came up that in fact, in the case of one of these discontinued roads, the landowner was liable. And we were trying to figure out how we could make them not liable.
Yeah, that's another whole statute, and they had proposed some possible wording for that someplace in here.
I mean, is there any way under the landowner liability law not that we probably want to edit it, but to make it apply to these roads? I mean, I thought it did. That was a shock to me that day.
What I'd suggested was doing something similar to it, so it'd be like 159C or something like that, to allow for limited liability for someone who maintains a public easement where the municipality does not.
That wouldn't be a bad idea, because that would be it wouldn't mess with existing and it would make it
Right.
clear that they're.
That is not a term clarification, but that would be one of the priorities that we had talked about. in terms
Because
of-
the liability, somebody had liability, right? They couldn't even plow into their house. The town stopped like 500 feet away and they were told they couldn't plow it.
I know of at least 2 cases where a road is closed to.
We were trying to figure out how to get around that because the town told them they couldn't because they'd be liable. So if we put a paragraph like that in that made it clear they weren't liable, then in theory they could plow
Yeah,
it.
this is one place where I don't quite understand how, the main courts have said that it's okay for the landowners on the discontinued road to maintain the road. But it's not okay for the landowners on a road that's closed to winter maintenance to provide winter maintenance.
Because they're two different things. If the road is closed to winter maintenance, it still is a town way. And it's still subject to that obligation on the part of the town, and the town is also liable for any defects in maintenance under the Highway Defect Act. So that's why the concern is, we just don't want private individuals touching it. I know it, but that's the reason for the distinction, as opposed to the on a public easement. If I have an easement to get to my property, I have a right to maintain that easement. That's implicit in order to do that. So if the town doesn't maintain the easement, I still have the right to maintain it, and the town's not liable for that defect.
But that's only if you have an easement.
That's correct. If it's a town way, I can't go out there and repair the pavement or something, because that's a town obligation, and the town's liable for what happens out there.
Right. And see, this is the thing, but in most cases, they're thinking the town way is a road that they're actually actively maintaining. But we're talking about a town way where they're not maintaining
It's
it.
not a town way, it's public easement.
Well,
No, you know what I mean.
I do.
Right,
Yeah.
it's a less, think of it as an in-between road status, and if the town doesn't maintain it, then those people who live along it, who need it for access, have the right to fix it, but it's at their own risk right now. And so what we're talking about is limiting their liability if they reasonably take steps to maintain the road so they can use it, because the town isn't doing that.
Carla had a comment on that. She says, she's talking about the proposed language that I had submitted. The landowner liability law. This proposal focuses on limiting the liability of landowners who privately maintain their own property or personal injury damages. It does not address liability protection for landowners for environmental damage caused on a public easement. And I agree, that's one piece I missed that should be in there. This has been one of the issues, is that if there's environmental damage because of somebody else using the road that you're maintaining, then the landowner is liable, even though they're not the ones that caused the damage, and we need to have something in there that protects them against that.
Yeah, I don't know what kind of environmental damage we're talking about there. Is it?
I can show you pictures.
Yeah, well, I know, the logging truck can come through and rut the road, and then there's a washout. Is that what we're talking
You
about?
know, what we're talking about is where somebody, whether it's a logging truck or ATV or four-wheel drive or whatever, they leave ruts down the road, which channels the water. It won't let it get out of the road, so it gains speed, gains momentum, gains volume. And then at some point, it spills off of the road and goes down into the watershed.
I think we
and
talked
takes all
about
the
this
soil with it.
like several meetings back, but I mean, I do think that falls on forestry and their enforcement of forest practices. And if you're a landowner that has a forest practice out there, a forester should be out there checking the condition of it. And if there's an environmental issue, it should be dealing with it.
Well, that's fine for forestry, but what about where it's a discontinued road and somebody with their.
Well, I know, but we're
four-wheel
talking
drive?
about logging operation. You were talking about logging operations and logging operations doing that. That's the responsibility of the landowner to have the logging operation, have the forestry practice done.
Mhm.
That's their responsibility to leave it better than they have it.
Mhm. What I'm saying is where it's not a logging operation, there needs to be some protection for the landowner.
It's a bunch of kids with an ATV or something, and not to pick on ATV.
No, I know, yeah, but the ATVs, that's when we come out and do enforcement, they're not allowed to be there.
Yeah,
Okay, what if it's somebody with a four-wheel drive pickup truck who comes through in the height of mud season on a day when there's a torrential rain and nobody's around to see it, so you don't know who did it? And the landowner becomes liable because there's.
So has the landowner ever been liable in that case?
That's what I'm kind of wondering.
That's what it's saying.
So they've been charged by DEP for violations for a truck?
I don't think they
I don't
have.
think that's happened.
That's what I've been told is one of the objections, is that there is no protection, that the landowner is liable if there's.
Technically, they're right. The landowner is liable. Practically, I don't think the landowner's ever been held liable. Not unless the landowner had involvement. I'm not aware of any case.
I know I've heard complaints about it, so.
I know, in my case, if their complaint comes in, DEP alert, whoever's in play, calls me.
Mhm.
And says, this happened because of ATV, or in some cases even snowmobile. You guys need to address this because we're not going after the landowner, and that's when we get involved. And we've always gotten involved in them on that front. Now, we wouldn't with a pickup or whatever, but I'm not aware of any cases where they've ever But you're right, forestry, I mean, we just saw a logging operation recently that somebody should have gone in and probably jerked the landowner around for their practice.
Yeah, I mean, they have laws and rules that they enforce for that.
Yeah.
All right. I think we've got some structure here on that one and Carla's concerns to incorporate in that, so, all right.
I
Okay.
had some additional ones on that language too, but I can submit them in writing.
Great, if you could get them to me, that'd be great, thank you.
Okay, Title 17 and Title 17A, again, maybe we should be checking with law enforcement on these and see what they say about them.
Mhm.
So let's skip over that. What do we got left, Jay?
Is somebody gonna reach out to?
Yes,
Yeah, who's
Yeah.
who's assigned to do that?
Heather will help us put it together.
Yep.
Okay, super.
Transportation, I think we took care of private way
Yep.
concern on that.
Yep.
Liquors,
That's not something that's a big concern.
no,
Traffic,
bicycles, roller skis, toy vehicles and scooters. Yeah,
I'm
we
not
talked about,
seeing hoverboards or electric bikes or single wheels or anything else that we want to add those to.
even more fun. Are we talking about private roads here?
Under, yeah, under, you know.
So we can clarify that.
operation of a vehicle exceeding registered weight.
Mhm.
It has an exception for private ways. And it said, since public easements are public but are not maintained by the public should certainly have an interest in protecting such roads from abuse and damage. On privately owned roads, it should be up to the person who owns and maintains the road to allow or prohibit overweight loads. So the exception here should be for privately owned roads and not for public easements.
How the heck do you get there?
I'm gonna have to look at that one just to be sure.
You ruin my road. I'll be in the middle of it to tell you to fix it.
And then you get on public.
All right, we'll move on just to be interested, but I'll look at
So
that.
that exception is strictly listed as private ways,
Mhm, mhm.
and you think private way in this case is just private road?
Privately owned road.
I'll look at that section, see if we agree, probably do, but take a look. All right, municipalities and counties, street trees,
It
okay.
says the owner of a private way. Well, then you're not the owner of a private way, that's a public easement.
Well, you're the owner of the fee underneath the public easement, but yeah.
So you're saying private way here should be private road?
I think so. A privately owned road.
What is this reference? Cutting of tree.
Statute says it does not abridge the right of the owner to lay out a private way. Well, public easements are laid out by the municipality, not the landowner. So if they're talking about the owner laying out a private way, it must be a privately owned road. Again, these are not ones that are huge problems, so
Right.
we'll probably have to major on the majors for now.
Yeah, I think that's a good idea.
There's a comment there that says that. That's so beautiful.
Yeah, the context though is for the purpose of preserving and increasing the growth of trees on land abutting any public way or located on uplands adjoining any river or other body of water, municipalities may set aside land not exceeding 5 rods in width And then when you drop down, it doesn't, yeah. I don't think this has caused a lot of confusion so far. Let's put that in the parking lot, so to speak.
In the private way.
Yes, private road. Public utilities, 2503,
The private way before the legal acceptance of the private way as a public way. Well, if it isn't the public way yet, then it must be private.
Not swooping in paper streets.
that's for application, for a old permit or a location permit for utilities, is that?
That might be reference to
Yeah,
something.
Let me
Paper
look at the
streets and public.
yeah, I'll look at the context.
And I'm afraid I was trying to save paper, right?
No, I understand.
Printing everything like that.
I appreciate you were trying to sort of save paper.
But not really.
Yeah, exactly. This section 38 is what the sewer statutes.
Hmm?
38, 1151.
I just still more. I thought we were at the end of it. Oh dear.
Wait, there's more.
Again, I don't think any of this is really critical stuff.
I think the critical stuff is right at the end with regard to Title 23, Section 3101 through 3105, which deals with road associations, how you start one.
Yeah, I think the main issue here is that the title on the whole chunk there is the private ways statutes. And they really primarily deal with private roads. There's a subset in there that some of these private roads have been accepted as public easements, particularly under section 3105A. For the purpose of allowing the town to use snow removal equipment on the road. But it's kind of confusing to label the whole bunch of statutes there as the private ways statutes when what they refer to is private roads.
Well, I kind of agree. Because I'm the one who pushed to have that retitled to private ways and roads. You could take subchapter 2 and say subchapter 2A, and it pertains to road associations for public roads, or Ryan's, which is a public easement, but it has a private road association on it.
Because the association formed when it was a private road. We just kept the association in place.
For example, though, if Roberta lives on a public easement, she could, with 3 or more neighbors, get together and form a road association. So I think that this road association pertains not just to private roads. Primarily, it is private roads, but it also can allow someone who has a public easement that isn't being maintained by the town to put together a road association going forward. So that's why I would probably say private roads and public easements for this section.
Or what if we just say all
but when you-
roads except town ways?
Yeah. All roads but town ways. I agree that's what it would affect, Ryan. I don't think we can call it that, though.
Yeah, because then you'd have state highways.
Yeah, that's true. But 3105A definitely is public easements. It's talking about use of public equipment on a private way, but what it means is the town can operate on a public easement with town meeting authority or town council, city council authority. So I can work that up if you like.
Yeah, just be careful when you word that it's not all town councils have that authority, right? So some town councils still have legislative authority vested with the town meeting.
Oh, I understand. Yeah, usually it's limited to budgetary when there's that kind of, but I know what you mean. You never can tell. So we'll say the legislative body and make it clear. All right, we are now at 4:35, 5 minutes longer than I said we'd go. But I think we've gotten through public easements, private ways, and public ways. The only thing left is private roads. We have homework assignments. If I can ask for one small favor, let's try to keep the amount of paper and I'm guilty of this, keep the amount of paper we generate to a minimum so that we have fewer things floating in different versions of it. Get it to where you're happy with the final document and then we'll move it forward. Does that make sense?
Trouble is, I think I have a final document and I bring it in, everybody else has other suggestions, and then they're changing it.
I understand. It's a dynamic environment.
But before we totally move on, can you agree to changing the heading on that subchapter to, instead of saying private ways statutes, private roads and public easements if you want, but at least take out private ways.
We will make it less confusing. Absolutely.
I think that's the main issue.
I think that's a great suggestion. When do we want to meet next in November? I don't want to be here Turkey Day and neither does anyone else, so that's out.
We could have a big turkey dinner.
We could.
Is November 9 too soon?
Yes. I won't be ready.
And November 16?
Today is,
Oh, November, we're talking November. I don't know if my calendar with me, but I don't think I've got anything on the calendar for November.
November 16th is
All right.
like
4 weeks away.
It's 4 weeks from now.
Or we go the week after Thanksgiving and do November 30?
So that would give you 6
if
weeks.
everybody promises to really be diligent on their homework, we could do that.
Do what?
The 30th,
Oh, so you're saying even the 16th is too soon?
16th, that's fine by me.
16th is okay with me.
I can do the 16th.
Give us a little more time to work after that.
Do you want it to be a whole day or just?
Oh, God.
Well, I'm just saying.
We have a lot to do.
Yeah.
2 hours is enough at a time, I think.
So, because I think that'll be your final push, right? So it's up to you guys on how much time you want me to schedule for it, so I can find a meeting room.
November.
What time do you want to do this on November 16th? You want to do this,
Doesn't matter to me.
noon to 4?
Okay. Are we ordering
Is this,
pizza?
Yeah, we could order in pizza. We'd take up a little
Take up
contribution or something.
yeah, we could go that way. We're not, that's not gonna be open for public comment that day either, right?
Let's not hold a public hearing. Let's noon to 4 and we'll pull through as much as we can with the idea that we want to have actual proposals and the language in front of us for some of these proposals we were trying to address terms and then a couple of the priorities, but really we've got to get the terms done and we have to pull through on private roads next.
Do we have the ability to like live edit that day?
What do you mean by live edit?
Well, like, I mean, if we were going back and forth on terms,
We should be able
could
to,
we draft and redraft so everybody can see and then finally agree to something?
As long as I have the Word documents, I don't mind
we
doing that.
could do that on screen.
Yeah, and you
Edit the
guys
Word
can
document.
see like what I'm,
Right.
do you know what I mean? What
It's
I'm
not gonna be
doing.
like Google Docs.
No, I'm
But-
just saying,
no,
but I mean, if everybody can see it and we're trying,
Yep.
sometimes.
While we're all in one place.
Yeah.
right?
Now,
Yeah.
if I send you something PDF, though, can you edit it or? is it-
No.
I can actually, I have the super duper Adobe. So, and I can convert it to Word. So I do, because we get the special stuff for the positions that I'm holding. So.
Okay. All
So
right.
can I ask if we can just clarify what we're responding to? Because I don't want to waste time on responding to things that we're not going to take up. So if we're just going to cover terms and then we're going to work on some potential language for Title 12, then I can prioritize because I'd really like to take a vacation.
Really?
Yeah.
Vacation,
Before the next session.
Yeah.
Terms, we're going to cover, and that Title 12 piece. And I will look at landowner liability. Okay, so I think that covers it.
Can we
Okay.
narrow the terms somewhat to mostly concentrate on the critical terms?
Yeah, we're gonna concentrate on the critical terms that we really need to concentrate are public way, public easement, private way, private road.
I was thinking even smaller than that.
Well,
I was thinking
we-
leave out the ones that we
we-
said aren't much of a problem.
Right, we're going to leave out the ones that aren't much of a problem, the ones that have their own definitions for their own sections and aren't part of the state highway law or the state motor vehicle law or snowmobiles or ATVs, leave them alone.
So like
As long as-
20, we said public way in 29A, we're just gonna leave it vague.
Correct.
We may want to get some additional feedback. I don't know how to do it between now and then, but you know, Lieutenant Scott may give us a lot of, yeah, don't mess with that.
And we'll hear that.
Mhm.
But is he, I mean, how are we gonna, is he gonna be here that day, or are we gonna hear from him between now and then, or what do you think we should do?
Heather and I will put together a letter and we'll let him know what some of the things are this commission's looking at. We'll have some feedback from him, I'm sure. Whether he wants to attend, that's up to him. He'll certainly be free to attend if he'd like. But we're not gonna hold a public hearing. We probably will have the little public comment section at the end, but we're really trying to focus on what we have in front of us.
I agree.
Any other thoughts, comments for today? Going once, going twice? Motion to adjourn?
So moved.
Thank you all.
I think we're making progress.
Thank you.
Thank you, Heather.
Bruce, we'll have to somehow come up with a better way to let people know. Way. Yeah. I know, that's probably me, and